Okay, we are underway. I'm pleased to convene the 54th meeting of the Massachusetts Gaming Commission on February 28, 2013. First order of business is approval of the minutes from February 21. Commissioner McHugh.
Colleagues, I circulated the minutes last night. I don't know if you had a chance to read them. If you haven't, we can take them up next week, but if you're ready, comments are welcome, and then we can approve them.
Did everybody have a chance to?
I did.
Okay.
Just a quick note on page 4 where we talk about the preparation for Region C discussion. About halfway down the paragraph, Steve, it'd be great if we could identify the parties that we'd like to hear from and have protocols in place. I think about a year ago or a few months ago, we actually approved kind of a public speaking process if we decided to have public comment period in advance of one of our meetings. So I guess, just to make the change that we do have protocols in place at such time when we wish to use them.
Okay.
The only comment I had, Commissioner, was I couldn't personally attest to whether the summary of the racing regs report, the racing report, is accurate. And
where are you?
On page 6,
right?
It's where David Murray is. It's recounting his highlights,
right? And
it's probably worth having David or Director Durenberger or somebody just read that through. We wouldn't want inadvertently to somehow misstate.
Director Durenberger's already weighed in and said that this is all
good. Fine.
But that's a good point. Yeah.
Fine. Then I'm set.
Good.
Anybody else? You want to move?
All right. So I move that with the change suggested by Commissioner Stebbins, that the meeting minutes be approved.
Second.
All in favor?
Aye. Aye.
Opposed? Ayes have it unanimously. The next item is under administration, and we're going to spend some time talking about the schedule. Everybody knows we've been trying to figure out how we can move, how we can speed up the process, and we've been working back and forth with the various bidders to get information from them and working on the process ourselves. And I don't know who's going to lead this discussion.
I thought I'd begin and then ask Commissioner Zuniga, with whom I've been working, and our colleagues from PMA to join in at the end. And I thought I'd spend a couple of minutes going through some scenarios that we've...
Yeah. Do you want it?
No,
are you going to go there? Oh, you got one. Oh, cool. Wow.
I mean, this is a high-tech up.
Wow. You the man.
So what I wanted to do today is go through a number of
our guest, Rep. Orell. If you can't see that, you might be interested in this. If so, this will bear on some of your folks' concerns.
What I wanted to do is go through some scenarios that we've put together to actually plot out in more detail than we have in the past the sequencing that's necessary in order to get to the destination we're all collectively trying to reach, and focusing on the Category 2 licenses as an illustration, and probably a stalking horse for the Category 1 licenses as well, and illustrate in the process that we really have 4 partners that are necessary to work together to make this occur. Any result that we try to achieve occur. The commission is one, the applicant is the second, the host communities are the third, and the cities and towns are the fourth. So those 4 surrounding communities, those 4 really have to work together to make this process work, and the results, any results we pick, achievable. This is the schedule that we see every week, and it's got all of the commission's activities and all the commission's doings outlined on it. On the next slide, I want to zero in on just the part that deals with the Category 2 licenses. And this is the schedule that we're working on right now that has an end date of an award of a license on December 2nd. That's the date we're trying to achieve, improve on, and that's the date we're trying to better, and that we've been talking about. There are a number of key dates on this chart that drive this outcome. The first is the finishing of our suitability investigations by the IEB, which is the end of April. And that's something that's largely within the Commission's control, but not exclusively, because it depends on us getting the information that we need to do the investigation from the applicants. The second key date on here is the signing of the host community agreement, and on this chart, it's scheduled for August 5. There has to be, by statute, a 60-day period between the signing, actually between the request for an election after the signing, but between the signing and the date that the host community agreement is actually approved by referendum. Minimum 60 days has to pass between those two. Then there's the surrounding community agreements, and they have to be executed by the time the application is filed. So the host community agreement is approved by the community, the surrounding community agreements are signed, then the application can be filed and we can begin to consider it. That is entirely beyond the control of the Commission. That is something that the applicant and the host communities and the applicant and the surrounding communities have to do entirely on their own. The next key date is the deadline for receiving the Phase 2 application, and then our processing of it that would lead to a December 2nd license award. So that's the way things currently exist. What isn't shown on here, and you will see in the next scenarios as we talk, is that there has to be a provision for dealing with situations in which a host community that the Commission is a surrounding community that the Commission is designated as a surrounding community, and an applicant have a process for reaching agreement if they can't reach an agreement on their own. And we've drafted some regulations that are incorporated into the next scenarios I'm going to show you, but it's important to understand that we can't consider as a Commission the application until that process is completed. That process probably, if it runs its full course, will take another 6 or 7 weeks. So in a worst case scenario, that would extend this date sometime into January. It's just not shown there. So now let's take a look at the first scenario that we've done. We thought, and the chairman mentioned a few weeks ago, that it would be aspirationally useful to think about issuing a license sometime in early September. And so the first scenario that we put together was, what do we have to do in order to make that happen? And so that first scenario shows what has to happen in order to make that happen. The first thing that has to happen, and the first thing that the Commission has considered, is moving the date for completion of the investigations back by 2 weeks. That, again, depends on whether we get the information from the applicants and how we process that information and how we get the supplementary information that we work on. But we think that's a realistic thing. The other thing the Commission controls...
So we're moving it back from when to when?
From the end of April to the middle of April, moving it back by 2 weeks.
Just split back and forth. We have there April 30th, and we are saying now April 15th.
Yeah. So this is now, we're on the first scenario. The other thing that we have control over is our processing period. On the original schedule, the current schedule, this is a much longer period. We think we can move this back and condense it by shortening the hearing period, by shortening our review period.
This is for the reviews of the background checks.
Of the background checks. The IEB finishes the background checks. It gives us the results. We take a look at them. We have a hearing, if necessary. We may not have to have a hearing. But in any event, even if we do have to have a hearing, we think we can condense that by a significant amount. So, if we do that, then in order to achieve the early September date, the host community agreement under this scenario would have to be executed by about mid-May. May 17 is the date that we've chosen here, because that 60-day period has to run, and then there has to be some time for the Commission to consider the RFA2 applications, the site-specific applications as they come in. The surrounding community agreement has to be executed by July 15, which is the end of the 60 days between the execution of the host community agreement and the referendum, that's time for the surrounding community agreement to be executed. And then once those two steps have been taken, the RFA2 application can be filed. What's new on this line is a consideration of what happens if there is no agreement between a community that wants to be a surrounding community and the applicant. And we have built into regulations that we'll talk about later today a process for doing that, a process that begins when the host community agreement is executed and the call for an election occurs. At that point, all the surrounding communities are notified, and at that point, they can begin negotiations with the applicant, letting the applicant know that they want to be considered a surrounding community, and work with the applicant to see if they can reach an agreement by this deadline of July 15th. Thereafter,
Just to make sure, they could, the applicants and surrounding communities can be negotiating before that if they want.
They could negotiate today.
Right.
And ideally they are. But this is,
Well, that's happening.
this is happening anytime along this red line here. But this would, this date, this mid-May date, would begin the formal process in the sense that there'd be a notice to the world that the host community agreement had been signed. The contents of the host community agreement would be available. Notice would go via the commission's website to the entire world that this had been done, and those who were interested in being surrounding communities would be put on notice that now is the time to start, and here's the dimensions of the project that you may want to take into account in deciding whether you're a surrounding community. In any event, we get to mid-July, July 15, and that's the time that the commission receives would have to receive, under this scenario, the Category 2 applications. It would consider those applications over the next month and a half, almost 2 months, and then would make a decision by early September. Now, all of these dates indicate orders of magnitude. They're not exact dates, but they indicate orders of magnitude that we think are reasonable. There'd be some, with all of these dates, some modest changes, no matter what scenario we approve. Suppose, though, the surrounding community and the applicant, a surrounding community and an applicant, can't come to an agreement as to whether the surrounding community is a surrounding community. Some community wants to be a surrounding community. The applicant doesn't think that it is a surrounding community. They're at impasse. What happens then? The commission ultimately has the responsibility for deciding under the statute who's a surrounding community and who isn't. And we're going to have regulations, and we've talked about those regulations that describe how that process is going to work. The statute says that we have to do that after receiving and reviewing the application. So the application is filed on July 15th. We take a look at it. We have to have a process for deciding whether some community that wants to be a surrounding community is or isn't a surrounding community. So our regulations that we're proposing are going to say that yet surrounding communities that want to be surrounding communities have a certain amount of time to file with us an application. We'll look at the application, we'll listen to the applicant, we'll listen to the surrounding community, and then we'll decide whether the surrounding community is a surrounding community or not. If we conclude that it's not, then that's over, and we move forward on this line down here without worrying about the involuntary surrounding community. If we conclude that the surrounding community is a surrounding community, then, again by statute, the surrounding community and the applicant have 30 days to work out an agreement. And if they can't work out an agreement, then the statute says the commission has to have protocols for ensuring, that's the word that the statute uses, ensuring that a surrounding community agreement is reached between the applicant and the surrounding community. So our regulations that we'll discuss later today, has such a process. Basically, what the commission, the drafts envision, is that there'll be a period of time for the surrounding community to file an application to be a surrounding community, for the commission to decide that it's a surrounding community, then the 30 days for a voluntary negotiation between the community and the applicant, then arbitration. a period for arbitration and protocols and procedures for that arbitration to occur. At the end, the arbitrator makes an award and a judgment, and the surrounding community and the applicant either sign an agreement that they negotiate themselves after looking at what the arbitrator's done, or that's based on the arbitration award. They can do either. But if they don't do either, then the commission will consider the arbitration award to be the agreement and move forward. Then the commission has, and the commission then considers the application with that piece added to it, and takes within 2 weeks, takes 2 weeks to make a decision and make a license award. So this shows, is an important consideration to be thinking about as we move forward, because it shows that, once again, the date for the license award is not entirely within our control. We can aim aspirationally for early September, but unless the applicant and the surrounding communities come to an agreement, there has to be a process, and that process is inevitably going to stretch out the award date, in this case by about 2 months, a little over, by about 2 months, about 7 weeks. And so, so that is how that scenario plays out.
This might be a good, the key, a very big step here is getting the background checks done and approving the applicants as suitable by April 15th.
Right.
Which I think bears on some of the feedback you've had from various people you've been talking to. Do you want to, so this is our best possible scenario.
Right.
If everything went right, this would be the scenario that we would hope for. But there's been some feedback that suggests that this is more than some of the bidders can manage.
Maybe I'll do it from
Yeah,
here.
yeah, good.
So we have, I'll just speak loudly so we can hear. So I've spoken to representatives from the 4 slots facility applicants to see whether or not this September 1st aspirational deadline is, for lack of a better word, doable by each of those different applicants. And I have different reports from
Excuse
each.
me, one sec, John. Is the sound okay? Is the sound okay? Can you hear him? Okay.
And so I have reports from the 4 applicants, which I'll give you now. Plain Ridge Racecourse has indicated that the September 1st aspirational deadline is completely within reason. The same remarks come from the Raynham facility. They both indicated that they could meet that September 1st aspirational deadline. The PPE casino application, the Quartersack application, they noted that that they've reviewed the schedule and they believe that November is more realistic than September as a deadline for completing the tasks necessary for the commission to award the Category 2 license. They will, of course, work with the commission to expedite the processes as much as possible. And then the final response from MG&E, they note that in response to the inquiries from the Mass Gaming Commission to each applicant asking if the targeted September 1st date for Category 2 licensure should be modified to a later date, MG&E believes that it should be moved to a later date since the development approval process is complicated and has many requirements and calls for a significant public participation. Notwithstanding the above, MG&E intends to meet any deadlines and requirements that the Commission may set.
And the essential issue for those latter 2 parties is that they don't have a site yet, as far as we know. Is that?
I think with some of their bigger considerations were relating to how quickly they could get some of the host and surrounding community agreements executed. And there are forces obviously beyond their control on how they could get those executed. Those are some of their considerations. And then I believe that site considerations may be consideration with at least 1 or 2 of those 2 applicants.
Right. Okay.
And Mr. Chair, in discussing this matter with Director Wells, it creates an issue with regard to completing the background investigations,
Right.
because there are qualifiers out there that have not been identified as of yet, which makes it impossible to start those investigations because we do not have the information. And the reason we don't is really that those deals have not yet been put together. So it not only affects the host and surrounding agreements, it affects the timeline on the background investigations.
So that illustrates, the Commissioner Cameron's comments illustrate that although this looks, the completion of the background investigations looks like something completely within the Commission's control, it really is, that just reinforces the point that we made earlier. It's a collaborative venture between the Commission and the applicant. So that's an outline
Sorry,
of.
just one
Yeah.
other question, sorry. Could you, if, given this best case scenario, how does that relate to the special election deadline? Is it, people are asking, is that feasible? A lot of communities are trying to think about, how does that fit in with this particular version?
Well, if the special election is the special election to select a successor to Senator Kerry, and the question has arisen, could we have the referendum on the Category 2 license, Category 1 license, Category 2 license, and that election at the same time? In order to do that, that's June 25, you'd have to move the host community agreement, complete the host community agreement process 60 days earlier, which would be about April 23rd. You'd have to complete the host community process by the third week of April, which is 7 weeks away.
And you'd have to have all of the applicants, qualifiers, qualified.
That's right. You'd have to finish the investigations. You'd have to finish this process. We'd have to truncate this process down here to go back to at least April 20. No, I'm sorry. You wouldn't have to do that. This process would be all right. But you'd have to have all the investigations done. Yeah.
The main reason we put this here is for reference, because we have heard that people may want to, cities or towns may want to have that election be at the same time. It's just a milestone for illustration purposes. It's not driving any of the schedule.
No, I understand that, but I just, I wanted you to explain why that is.
Yep.
Just as we're, if let's say two of the Category 2 applicants meet this schedule, which two of them have said they think they can, I guess there's no reason for them, if they wanted to go ahead and have the elections on that date, right, on the special election date. In other words, we can do these, we'd have to do these all at one time. If we get candidate X qualified, we can let them go, and they do the host community agreement, they do the referendum, and nobody has to wait until everybody else comes along. They could then go ahead and file their Phase 2 application, but we just wouldn't be able to make a decision until everybody else had come along and caught up with the ones who were out front. Is that right? So if Plain Ridge says they can make this date, or Raynham says they can make this date, they could be working with their communities with the possible, maybe tying their election, which would be good for the communities. It saves the communities time and money if they could coordinate with that date.
That's right.
Saves the applicant too, because the applicant picks up the election
Picks up the
expenses.
cost,
Yeah.
That's predicated on one assumption, if I may, Mr. Chairman, that once the IEB finds suitability, as soon as they find suitability, one applicant, that they make for the recommendations and they move forward. As opposed to if they're gonna find all four suitable at the same time, that changes the equation a little bit.
Right, but it's from what we're hearing from the applicants, according to Ombudsman Ziemba, that may be that our hope that we have had for Category 2 may be non-feasible if the information doesn't come in.
I think there's a policy issue here, Mr. Chair. I mean, do we want to enforce hard and fast deadlines, or do we want to, within reason, consider extensions due to some of these circumstances? I think Mr. Ziemba and Director Wells were intending to meet with all four in an effort to ascertain more information about their process, their concerns, so that we have accurate, timely information to consider.
I agree with, I think there is a policy question here, and I think that that all of this discussion and looking at these things is providing a foundation for making decisions about deadlines. We made a decision about a deadline for applications, the Phase 1 applications. We stuck to it. We've got to move this process along. We've got to move it along in a reasonable way in collaboration with our partners, but we've got to move it along. The governor and the legislature are already spending the license application fees, and we ought to catch up with them and urge our colleagues and partners to catch up with them. So at some point, I think we have to establish deadlines. Not today, but we need to do that.
Would you consider setting a deadline once all the suitability investigations were done? You wouldn't do it in advance of that?
No, the deadline would be for when you have to have all your qualifiers submitted. That's,
Right.
that's the gating mechanism for us.
Right.
Oh, okay, right.
Because it's the problem, you know, right now, at least 2 bidders don't have a landowner partner yet, as far as we know. That's the trigger mechanism. The trigger mechanism.
That's the earliest trigger mechanism.
Yeah, is when we have all the qualifiers.
Right.
Okay.
Once we have all the qualifiers, the ball's in our court, unless they contest a decision.
Well, in terms of the qualification process,
Right.
yes. It seems to me that one might consider 2 deadlines, one for submitting all the qualifiers and then for the RFA 2
Right.
application, farther down the line. But-
If we could, just a clarification to that process, it is not unusual, and this happens frequently in other jurisdictions for, a financial investor to be added or subtracted somewhere in the process. So there's been a good faith effort. This is our team. This is, the individuals as we know it today. But there probably will be a need for 1 or more applicants for us to conduct a supplemental investigation in which we look at an additional qualifier.
Right.
That is not unusual.
Even after our deadline.
Correct,
I agree
correct.
with
So I
that,
just
yeah.
wanted to clarify, that may be something, we're prepared for that, we're intending to be reasonable about all of these issues, but what we can't be in a situation is we're completed with everyone else and 1 or more just hasn't put their deal together at all. And that would be a situation that I think we would have to consider some deadlines and let people know well in advance that we intend to stick with deadlines.
I'd like to make one point. Regardless of, or in addition to our aspirational move of the suitability and our shortening of the review period of that suitability, the fact that we are moving in this scenario, the host and surrounding community dates earlier than anticipated, in my mind, makes this scenario a little bit more likelihood. The scenario that they won't reach a surrounding community agreement
Right.
because they haven't been
Haven't had
taking
much
steps,
time.
as much time, steps. So, and thus this later October date a little bit more likely. So.
Okay.
Let's, if there are no further questions, let's jump ahead to scenario 2. And scenario 2, by the way, these are all in your packets. They're not in the packets? Okay. Pardon me?
It'll be up on the website
Oh,
tomorrow.
they'll be up on the website tomorrow. So scenario 2 is really designed, I'm not going to go through it with the same precision as I went through the last one, but it's really designed to show how little wiggle room there is before we get into a situation where we really have to push things back. Scenario 2 really is designed to move the suitability investigation completion is the same. The review period by us is the same. There's a little dead time in here, and I'll explain that in a second. But what we've done is moved the time for the host community agreement back 2 weeks to the beginning of June, from mid-May to the beginning of June, and therefore extended the 60-day period into early August, as well as the date for having the surrounding community agreement done by early August. But this is really the important date. If we, and I'll come back to that, the reason for that in a second. If we do that, then we push back by about 2 weeks the date that we could issue the Category 2 license, and we push back by 2 weeks the outside date if.
By push back, you mean push out,
Push,
farther away.
extend is a better word. We extend the date for issuing the license to the end of September, and the worst-case scenario date we extend to mid-November. This is the important date because while there's no magic to August 2nd, it could be the July 31st, once we get into August, the idea of holding an election on an issue like this may not sit well with a lot of communities. That's the heavy vacation period. That's a period when voter turnout would diminish. That's, of course, up to surrounding communities and up to host communities. But the likelihood that there would be some reluctance to schedule an election then is not something that we can just lightly pass over. So you really have about a week and a half between the best case scenario and this middle course before you get into August. And that's really all I wanted to say about that. Let's go to the third slide, if we might then. If we don't want to have an election in August, then the early after Labor Day is the next kind of earliest date to have the election. So everything remains the same on this slide. We have the election, the suitability investigation finished. We have our determination finished at the same time. But we have the host community agreement now signed in mid-July, and the notice of it posted, and this process for the surrounding communities to be on formal notice that now's the time, if you haven't already, to get going with your negotiations. That's in mid-July. We have the 60-day period running through August and consuming August, and then we have a vote in early September on the host community agreement. We begin to evaluate applications if we get them. We have some dead time down here that we don't really need, we don't think, but it's there because we've extended this timeline out. We have then a deadline or an application deadline of September 10, right after the host community agreements have been approved by referendum. And we process, this processing time is the same, and we have a date of November 16 when we could issue a Category 2 license, unless we have to go through the involuntary host surrounding community process, which would drive that date out to December 22nd, which is later than the date we have on our current chart, but earlier than the date that would exist under the current scheme if we had this involuntary surrounding community piece. So this is designed to show how little room there really is between that first highly aspirational scenario and this scenario, which I suspect everyone would think they could make, and which, even if they didn't think that they could make, as a worst-case scenario, the Commission could think about making something that we adopt.
Well, and the good news is that this is your worst case, so, quote, worst case scenario.
Right.
And it's basically the same deadline that we've always been talking
Right.
about.
Right.
So that's the good news,
Right. Right. And that is the good news.
Right.
Yeah. So that is basically what I wanted to talk about in this context. And Enrique, Commissioner Zuniga, if you wanted to add anything, or our colleagues from PMA?
I thought that was an excellent summary. I would just point out something here, that the determination of suitability in this scenario is as early as late May, and conceivably the host community could schedule the referendum, request the election the next day, so that these could be pushed a little bit back. But what's really driving this scenario, as Commissioner McHugh explained, was the the desire to have an election in September, not in August, where low voter turnout is likely.
But that's the minimum requirement.
That's the minimum. It could be 90 days, so conceivably they could, these could help from the standpoint of some communities at least, to schedule this vote as early as possible.
Okay, so that's great. I mean, this is really helpful, and I hope it gives all of our bidders and watchers and communities, some in-depth understanding of what the issues are, what we're wrestling with. Clearly, we're going to need the cooperation of our bidders to be able to move our deadline. To move faster on Category 2 is going to take a lot of help from our bidders, and whether they can make it or not is a question. It seems to me, let me just suggest an approach here, that Ombudsman Ziemba and maybe Director Wells talk to all of the Category 2 people, applicants, particularly the two that are problematic with respect to schedule, come up with a recommendation for when we should require qualifiers to be in. And then we'll talk about that and see, I think we're balancing, as we always have been, the wish to move quickly with the wish to do it right, the wish to maximize quality, the wish to maximize competition. And we're going to continue to have that kind of trade-off. But as long as it's not wildly unreasonable, I think we're all open to waiting a little bit for qualifiers, but not for terribly long. So if you all could come back to us just as soon as possible, so we can decide finally whether to put a stake in the ground as to when qualifiers must be in, that would be great. And then we can deal with the second question, which is not urgent, which is what is the deadline for the application RFA 2?
Mr. Chairman, can I
Yeah,
mention
sure.
just two things? There's a couple of other slides, right, Angel, in here? Or was that the original?
Not in this version.
Not in this version,
Yeah.
okay.
Probably will be in the one that will be posted on the
Right.
website.
Right,
Just highlight some of the challenges, some of the
That's right.
main drivers that we talked about.
yes. Yeah, there's a nice little presentation, not little, because there's a lot of great work that went in thinking about these scenarios with the help of our friends from PMA, but that we will post that summarize just the drivers and the circumstances that make one scenario possible and comparable to the others.
Okay, great.
Great.
You might introduce PMA just to our audience so they get some credit for all the help.
Yes, thank you for the record, Scott Levy and Angel Carvelo from PMA, our consultants in all things scheduling at this point, who's been doing a great job at helping us out modeling this critical path, and will continue doing that.
Thanks very much.
Thank
Very
you.
well.
This was
Thank
really
you.
helpful. Thanks.
So, Ombudsman Ziemba, could we plan to talk about, can you make a recommendation to us next week, do you think?
Yes.
Okay, great. Great, thanks a lot.
Good, thank you.
The only other thing I think to talk about in schedule is just that we are, as soon as we can, we're gonna start layering in the build-out of all of our major departments. The hiring plans for the Investigations and Enforcement Bureau, the hiring plans for licensing, the hiring plans for all of our other major departments, but particularly those two that we're gonna need to start ramping up pretty soon. And we need the same kind of critical path chart, which means we're probably gonna need your guys' help some more. So we can be tracking the building of those departments and our internal systems, our CIO systems and so forth, with the same degree of intensity that we have tracked this. So we'll be in touch with you shortly. Great. Thanks again. Look forward to it.
Thank you.
Thank you.
Personnel updates, nothing particularly, I don't think. We have started a process, just beginning a process for a CIO and a CFO. And as you know, the Director of Problem Gambling and Research and Problem Gambling, the Director of Workforce Supplier and Diversity Development, and the Director of Licensing are all in the pipeline. Now, we have a distinguished guest, and in interest of her schedule, if we can do this, Todd and John Ziemba, I wanted to pull the surrounding community agreement conversation up out of order and do it now, if that's all right. And maybe start off by asking Representative Keiko Oral, who represents a number of the communities in Region C, to kick that discussion off with her own thoughts, and then she can stick around while we have that the conversation, and then that'll enable her to go back and get back to her work. Representative Oral.
Thank you, Mr. Chairman. Thank you, Commissioners, and I appreciate you taking the time and taking this out of order. I do represent the communities of the 12th Bristol District, which include Taunton, Middleborough, Lakeville, and Berkeley. And the community of Taunton is slated for the tribal casino. The commission, I've been in contact with Rosemary Powers, who is working with the governor's office in their negotiations with the Mashpee Wampanoag, and she has assured me that mitigation language will be included within the compact as they did with the prior compact that they tried to negotiate with the tribe. My concern is with the first compact, there was language that gave the commission overview regarding surrounding communities and who would be considered a surrounding community and what percentage of mitigation would be afforded to those communities. So I did not see that within the draft language, and I just want to make sure that the commission is aware that the surrounding communities are in a very different situation with the tribal casino as opposed to the commercial casinos. And I believe that you are aware of that, but I'm here to advocate once again on behalf of the communities of Lakeville, Berkeley, and Middleborough abutting the proposed Taunton tribal casino, because we haven't had the safeguards that have been put in place for the commercial licenses, and we haven't had the preliminary work done as far as what infrastructure changes, what public safety impact there will be, and we haven't had any money to do that. And so that's where I'm asking for the commission's help, for your continued attention to the differences between tribal and commercial casinos. And I don't know if the language that I included was sufficient, but I hope that that you're clear with my intent, that I'm wanting to advocate for those communities that are particularly affected by this casino. In talking with Ombudsman Ziemba, he also reiterated that you're constrained by the language of the compact, and I understand that, and we don't have a current compact yet. And I'm under the impression that it is going to be coming out soon. But again, I just wanted to impress that in the event that the language is also included, that you will have overview of the surrounding communities to this tribal casino, that I would ask for special consideration for the communities of Lakeville, Middleborough, and Berkeley.
Thank you. You've got the issues right. We don't know exactly what the deck of cards, so to speak, that we will be dealt is, because we haven't seen the compact
Right.
either. We have expressed concern to the governor's office that we would like to be a part of that conversation before anything is totally agreed to, because we have our own concerns, which include how you get to deal with the surrounding communities. When we went through this once before, the earlier compact was mostly going to be under the MIPA process, where the protection was going to come from. And I know we had conversations about whether we could provide community mitigation money. Was there a way to do that? And since we don't know what the next compact has, we can't really join those same issues. But we agree with you, I think, universally, that that's a matter of importance. But frankly, the big issue will be how we handle Regency. You know, as you know,
Exactly.
starting the 21st, at a meeting the 21st, to be held in Regency, we're going to rejoin the issue of whether we should continue to wait for the tribe, should we open it to commercial bids, is there some other alternative, whatever. If we open it to commercial bids, this will all go away, and surrounding community, your surrounding communities, or prospective surrounding communities would be dealt with the same way everybody else
Right.
is. So you might want to, this isn't the time or the place, but we're asking for speakers. Sorry? Did I say something wrong?
Not necessarily.
Not necessarily, Mr. Chairman, because there are a number of scenarios that could play out if we made that determination. One of which would be that some kind of a compact process goes forward in parallel.
Correct.
Yeah.
In
Right.
which case, those three communities
Are
would
still-
have the same
It's
issue.
the same issue.
Well, in that point, they'd have two things to worry about. They'd have to deal with what happens if the compact, what happens if the tribe gets the license, or what happens if there's a commercial license.
Well, even if there was a commercial license, and the Mashpees proceed with obtaining land into trust, they could conduct gaming by their own
Yeah,
right
right,
under
okay.
that scenario.
Okay,
And
so-
maybe
right.
that's, and this is only one of several. I don't want
There's
to.
a multitude of
There's a
scenarios.
multitude of scenarios.
But there will be some big decisions being made by the
Right.
commission, beginning a process starting on the 21st.
Mm-hmm.
And where you and your communities come down and recommending how we proceed on that is probably pretty important. I don't know which way you all
Right.
feel, but you might want to think about coming to that meeting as well
Mhm.
and letting us know.
Of course. Yep.
I know I'll see you there. Anybody else? Right,
No,
you're-
I think this is very helpful, and we did think about the surrounding communities, as you noted last time, and those three communities, and we'll continue to do that. But it's helpful to have the concerns reinforced as you have.
Well, and especially my concerns are that where the amount that was negotiated with the Commonwealth was rejected at the federal level, I feel that they're going to be going for an amount that's going to be less than what the 21.5% was that they originally went for. So that means that there's going to be even less money for mitigation.
Yeah.
And so, but it's still, I feel like it's still under the purview from the last compact. It could be different with this one, but under the last compact, it was within your purview to determine what percentage and who would be awarded that community mitigation with the compact. So if there were.
The distribution of that.
The distribution,
money
correct,
would have been up to us, yes.
correct.
That's right.
And that compact did create an interesting situation. I don't know, again, what the new compact will
Right.
have. But left community mitigation for Region C to the Community Mitigation Fund and the purview of the commission.
Correct.
Whereas if you were to compare that with the other two regions, well, there would ideally be direct mitigation from the applicants. It creates the disparity that you may be alluding to from the Community Mitigation Fund
Correct.
at the state level.
Yes, that is correct.
In other words, puts pressure on the Community Mitigation Fund for
Right.
only one region, or
Right.
one region more than others.
Right.
And
Which is
and
a big
that's an
problem.
important,
Right.
that's an important issue. Yeah.
Right, it very much is, and that's what you identified last time
Right.
around.
Right.
All right,
Very good.
thank you.
Thank you very
We're
much.
gonna have our
Thank you.
surrounding discussion conversation now, which
Can
is.
I just submit?
Sure, absolutely, yeah.
Really great, thank you.
Thanks. Oh, sorry.
Thanks for coming. Good to see you.
Thank you. Thank you.
John, as long as we're on this, John and Todd, do you want to lead us through that discussion?
So, Mr. Chairman, I believe that what we're going to discuss are recommendations regarding the protocols and procedures first, and then get into some of the comments that we received regarding the surrounding communities definition, because in many regards, the questions regarding some of the protocols and procedures and some of the recommended procedures that we're putting in place do address some of the concerns that we received pursuant to our request for comments on the definition. So I'm going to let Mr. Grossman take us through some of those conversations.
Sure. So unlike some of the other language that we've recently submitted, the surrounding community language you've seen before and has been, of course, circulated for public comment. And there were a number of comments that we certainly looked carefully at all the comments, and we've, Mr. Ziemba's compiled them all for you to be able to take a look at in an easy format. A number of the comments, though, we have been able to incorporate directly into our draft, and I'll just kind of go through the draft, or the principles that we included in the draft language and highlight some of the ones that were included based upon comments we received. So the first element of the surrounding community regulations discusses how a community would become designated a surrounding community. And we have identified 3 ways in which that can happen, and these were largely contained in the original draft that was previously circulated. First, you could, an applicant in its RFA2 application could designate or identify a community that it believes to be a surrounding community. The community then would have, in accordance with the language we've put together, 10 days to assent to that designation. So there would be no involuntary designations. Every community would have a right to decline if for some reason they wanted to any such designation. That's the first method. The second method, as the statute contemplates directly, would be a scenario in which prior to the submission of the RFA2 application by the applicant, the applicant and a community execute a surrounding community agreement. And that agreement is included as part of the RFA2 application, in which case the commission would automatically designate that community to be a surrounding community. And the third way that we have identified, which I think will be the subject of the most discussion, which Commissioner McHugh has addressed in part during the timeline discussion, is a situation in which after the applicant submits their RFA2 application, a community believes that they should be designated a surrounding community, but have not been in either of the first 2 scenarios. This provides a means by which they can petition the commission to become designated a surrounding community. And the methodology we have set up has roots in a number of different sections of the regulations, or the draft regulations that we have submitted to you. And I'll go through some of those points now. Most of them, of course, are contained right in the draft surrounding community regs. And what these say, essentially, is that a petition by a community to be designated a surrounding community must be filed with the commission no later than 10 days from the time the RFA2 application is filed. However, in recognition that certainly the community needs time to study the impacts of a proposed casino, to receive funding to study the impacts, and to just have time to contemplate the situation, we built in a number of other elements. And that is that the process really starts in earnest upon the execution of the host community agreement between the applicant and the host community. At that point, we have written into a different section that the applicant must submit to the commission a copy of the executed host community agreement. The commission will take that agreement, post it on our website, along with a mechanism that will allow any community that believes that it may be a surrounding community to be added onto our list. At the same time, that provides notice to each of these communities that they should at least be approaching the applicants to commence negotiations of a surrounding community agreement and to study whatever impacts there may be. To that end, in recognition of the fact that a community will need funding to study the impacts, at that point, this is now prior to the submission of the RFA2 application, we have prepared for your consideration draft language to amend the community disbursement section. As the community disbursement section of the regulations presently reads, a community can only apply for funds, and now we're talking about the $50,000 out of the $400,000 and any subsequent monies, can only apply for that funds by submitting a letter of authorization. That is, by agreement of the applicant as to how those funds should be spent. In recognition that we're now talking about an involuntary type situation, one in which perhaps the applicant does not agree that this community is a surrounding community, we have proposed language that it would allow for involuntary disbursements of those mitigation funds. We also recognize, though, that we're talking about the applicant's money. So it has to be dispersed responsibly. And we have proposed a standard that would have to be met to the Commission's satisfaction prior to the disbursements of that fund. And it contains language that essentially requires that the community be able to demonstrate to the Commission that there is a, I believe we use the term reasonable likelihood, that it will be designated a surrounding community, and that if it is not able to get the funds, it will not be able to properly study the impacts. And that will be weighed against the burden of providing the actual funds that will be imposed upon the applicant. So that addresses the funding element that would allow the prospective communities to study impacts of a proposed casino. So as the process moves ahead, now the applicant calls for an election or requests an election. The host community calls for the election. Now there's a 60 to 90-day period within which the host community must schedule the election. This, and I mention that now, as that is a chunk of time that the prospective surrounding communities will now have to start their negotiations, to study the impacts, to apply for funds. That's important when we look at the 10-day period that we've set after the submission of the RFA2 application, which may seem like a tight period, but we need to consider that we really need to back it up about 2 to 3 months, where you'd have the execution of the host community agreement, then there's a statutory 60 to 90-day period, but at minimum, let's say 60. Then there's a period of...
For the vote.
For the vote. Then there will be some period of time between the vote, assuming it's a positive vote, between that and when the RFA2 application is submitted. So the total amount of time that these communities would have to study the impacts and submit a petition, not negotiate a surrounding community agreement, mind you, but just to submit a petition to be designated a surrounding community, would be 60 days plus whatever time between the election and the submission of the RFA2 application, plus 10 days. So it is a substantial chunk of time, which will probably be more than that, but that's the shortest amount of time, by which communities would have to study impacts and determine whether it wanted to submit a petition to be designated a surrounding community. After that 10-day period, we have built in a 10-day period by which the Commission would have to evaluate the petition and make a finding as to whether that applicant, or I'm sorry, whether that petitioner will be designated a surrounding community
Is
or
it
not.
business days, 10 business days, or 10 calendar days?
Calendar days.
Calendar,
We
okay.
actually, it's I think good to point out now for our future discussions, there is a provision in the existing regs that talks about calculation of time. And it's consistent with the rules of civil procedure here in Massachusetts. And with certain exceptions, it's calendar.
Okay.
So.
We're all working weekends anyway, so.
Right. Especially when this stuff starts to come to fruition, I think
Right.
a lot of people will be working weekends.
Right.
So, so that's 10 days after the submission of the RFA2 application, plus another 10 days maximum for the Commission to make its finding. Now, when the Commission making its finding has legal significance, because that sets off a 30-day period by which the community which is designated a surrounding community now has to negotiate a surrounding community agreement with the applicant voluntarily. And at any point, they're welcome to do that. And we certainly encourage, the regulations were designed to encourage communities to enter into voluntary negotiations with the applicants and to hopefully come to agreements on their own volition without any interference, if you will, from the Commission. However, in contemplation of the fact that, by statute, we're required to come up with a scenario, a way to break any deadlocks, if you will. What we have proposed is that mandatory binding arbitration be commenced after the passage of that 30-day period. And we set out all the mechanics of how that would work, how you pick an arbitrator and all that stuff. The manner in which the arbitration is intended to proceed, though, is what we have referred to as a best and final offer scenario. So basically, each side will present their best and final offer, and the arbitrator essentially will pick one, with some discretion baked into that as well. But that is intended to encourage the parties to negotiate their own agreement and not find themselves in a situation where an arbitrator will be choosing one over the other. The arbitrator it will be given 20 days from the date, from that 30-day date, to conduct any proceedings and render a decision. Then we bake in another 5 days by which, after the arbitration, either the parties then go and negotiate their own agreement, or the arbitrator's report becomes binding and becomes the surrounding community agreement. All told, it comes out to, by our calculations, 80 days. That's if everyone takes advantage of every possible maximum timeline. 80 days from the date the RFA2 application is submitted until the time that the arbitration is completed, you would have a surrounding community agreement. So that is essentially the process.
Before you go on, are you finished on this topic? Go ahead, sorry, I didn't mean to interrupt.
Yeah, no, I think that pretty much touches on all of the highlights of the draft language.
Okay. This is obvious, but I want to say it anyway. You said that the surrounding community agreement begins in earnest at the signing of the host community agreement. And what you're talking about here is what we hope is the very infrequent and unlikely situation where the applicant and the surrounding community cannot come to an agreement to begin with. I mean, hopefully we'll never have to use this process once.
Right.
We have to prepare for it in case we do, and we might. But I don't want to give the impression to the bidders that and the surrounding community prospects that we don't expect them to be out there negotiating today, as Judge McHugh said, and all of a sudden get everybody's focus back on host community agreements. That's not what we're meaning to do here, right?
That's right.
Yeah, okay. And Ombudsman Ziemba is out there encouraging surrounding communities all the time to get moving now and talking with bidders on the same topic. Two questions. A scenario which I don't think you actually described, but it would fit into the same thing, is it may be that you've got a bidder and a host community agreement who can't, a bidder and a surrounding community prospect that can't agree on whether or not one is a surrounding community. That's what you just talked about. You might also have them have agreed that they're a surrounding community and not agree on the terms of the agreement. And the process, you didn't actually mention that.
No,
but
I didn't. That's right.
The process would be exactly the same, but the trigger is a slightly different trigger, so my only point. And in the way you're setting this up, is the commission bound by the arbitrator's decision, or can we second guess the arbitrator's decision?
No, we have, consistent with some of the policy discussions that took place, we've set up a scenario where the commission is really fairly hands-off in the language that's in these surrounding community agreements. We say, we want you to go negotiate it. If you can't, go to an arbitrator that you're going to select. And then even after the end of that, you still have a small window to go negotiate your own agreement if you don't like what the arbitrator said. So, yeah, we did not include any provisions by which the commission would review and approve of the agreement.
Good.
And that's designed to put the incentive on the parties to deal with this arbitration really seriously.
Right.
There's no windows, there's no doors. This is the end of it.
Right. It's good. I mean, it's like baseball arbitration. You know, you force people to negotiate towards the center, since you're going to pick one or the other is going to win. I think that's good. Okay. Do you want to go ahead and on other? Well, no. This is it for the surrounding community stuff, right? Okay.
Well, we had also comments from a number of folks on the
On
definition.
definitions, right.
Which we could go through each one of the comments, we could give you a general overview of the comments, or,
You know, we've been through this I don't know, I mean, I think we've been through this so many times, and this is a great job of summarizing. This, if it isn't available on the website, it will be. This is a synopsis of all the comments we've received from anybody, including bidders and individual citizens, and our reactions to their I don't think we need to go through that again.
They're very carefully done.
Yeah,
and
it's a great job.
There are just 2 points I would make that I think we are important to note, because there were comments we received from a number of different individuals. One is that we removed language from the initial draft that precluded a right of appeal from the surrounding community decision. So we struck that language. And the second was that we clarified, we believe, that when the commission sits down to make a surrounding community designation, it will consider what the definition of a surrounding community is, and that is to make sure that the community is both in proximity and impact, and not either or some combination of everything. So those were 2 comments that we certainly made sure that we included in here, as well as some others.
I think it's worth noting that I, for one, don't believe that there is a right of appeal. But if there is, we can't, by regulation, remove it. So the fact that that has come out is not an agreement that there is a right of appeal. It's just a recognition that if there is, we can't, by regulation,
Does the
remove it.
statute say there is no right of appeal?
The statute says there's no right of appeal from the licensing decision. This is part of the licensing decision. So that's for starters. And secondly, this is, in many ways, a kind of legislative decision from which I think there is limited, if any, right of appeal. But I don't purport to have mastered that. It's just it's not within our power to take away a right of appeal.
You're not really
if
an
one
appellate
exists.
court's judge, you just play one on TV.
Right. That's right.
Mr. Chairman, I have 2 other comments. I noticed that I neglected to include comments on a comment from the town of Holland. We'll revise that for what is posted on the web. And the other thing I wanted to note is that, again, what we're talking about today is going to be put into the regulations that will be then subject to another public hearing requirement. So all of those communities that may review some of the comments that are made here today and in some of the decisions or draft decisions that are put on the website have another opportunity to comment as part of that public hearing process.
Right. Great. Okay, so that's it for surrounding communities for today. Let's go back now. John, you could just stay here, and we'll go to your agenda, and we'll come back to the regs in a minute. So we'll go to the report from the Ombudsman. Thank you, Representative.
Thank you, Mr. Chairman. I wanted to bring your attention to 2 items that I wanted to bring your attention to right now, even in advance of final answers from me, because there's some deadlines that are quickly approaching. We've been notified of potential issues regarding the execution of surrounding community agreements. In some communities, there are provisions of local bylaws or charters that relate to what types of contracts can be executed by municipal officials without having to go to such a thing as a town meeting. Like, for example, a particular bylaw could be that no board or officer shall make a contract on behalf of a town, the execution of which shall necessarily extend beyond 3 years from the date thereof, except as otherwise provided by law, unless specific authority to do so has been given by the vote of the town. We are entering into the town meeting season, so there may be a need for some communities to address this issue as they go into town meeting to make sure that the community has the authority to enter into a surrounding community agreement, which would likely exceed 3 years in many cases, if indeed there are some of these local provisions. We're working with our outside counsel on other thoughts about this issue, on whether or not there should be any further official advisories from us on what communities could do in these instances, and hopefully we'll have that available shortly.
Okay, great, thank you.
But it's a good thing for applicants, obviously, to take note of as well when they're thinking about their timetables for approvals of surrounding community agreements. One other item is that we've been approached with an issue regarding what restrictions might there be on applicants who are involved in a ballot process, such as if they are involved in putting forward advertising in support of the ballot initiative or similar things. So what we have done is we've contacted the Office of Campaign and Political Finance, and they've given us some of the parameters that would guide applicants as they pursue any of those activities on whether or not they'd have to establish a political committee or a ballot committee, whether or not they would have to provide notices to town clerks. We have an email that we received from OCPF that outlines some of those standards. We'll put that on our website and give that information to applicants and communities. And then they should be encouraged to call the OCPF if they have any further questions, and obviously we're here to help as well.
Great.
And that's what I have to report.
Thank you.
Okay. Evaluation criteria, Commissioner McHugh.
All right, Mr. Chairman, following our last discussion of the surrounding, I'm still in surrounding community, of the evaluation criteria, you suggested some additional criteria and some restructuring of the existing criteria, and so what I did was take those suggestions and create a second version of our evaluation criteria matrix, and that's what everyone has before them. I was assisted as before by Commissioner Zuniga in this process, and so this is sort of a joint product. What we've done is we still have 5 categories. In each of the 5 categories, we have a number of criteria, some statutory, but now mainly commission criteria. This matrix still includes all of the statutory things that we're required to take into account, some mandatory minima and others that are more normative and evaluative. But it adds a lot of criteria that are commission generated. Most of the major evaluation criteria at this point are commission generated, and they have a statutory criteria and others as subtopics within the various criteria. As a result of this process, though, what's begun to happen is that the required evidence column on the right has begun to get some information. And that information is designed to become part of the application requirements. So the application design will flow from the major topics and the major groupings, and then we'll ultimately have the evidence that we require to support whatever the applicant says about how they're going to meet the various criteria. Before worrying and concerning ourselves deeply, though, with the required evidence, it's important to come to an agreement on the major topics and then on the 2 subtopics, and come to an agreement on that, and then we can begin to move forward with how we design the application from that. And then, after that, consider the various methods for evaluating the applications as a whole, or the parts of the applications, and put them together in a unified fashion. So that's what's before us. Discussion obviously is now appropriate and imperative. We are going to have a full day, I think, on
March
the 12th
right,
to really go through this and immerse ourselves into it. And we still have up on the website the last matrix, and it'll be replaced with this with a request for comments on it. And that has no deadline, so we're continuing to look for comments. I've said enough.
No, it's great. It's really good. Anybody? Go ahead.
Well, no, just to underscore that we've only begun to to populate some of the areas here about required evidence. There will be a lot more meat on that bone, not only in this spreadsheet, but of course in the form of response that we eventually draft. But all the components are here, and that's the reason of this format at this point.
Did you have any?
No, very
Okay.
well done, easy to understand. You can clearly see where additional populated fields will go, and I just
Right.
want to commend both commissioners for
Yeah.
a lot of hard work here.
I had a couple of things. One is purely form, not substance, but the term subtopic and second subtopic, they're actually sub-criteria
Yeah.
and not topic.
Yeah,
Yeah.
that would be less confusing.
And
I
second
think that's
second
right.
sub-criteria.
Right.
Is there anything for us to be careful about here? I want to ask this, even though I think I know the answer, but is there anything, by putting down, for example, a column calling required evidence, are we in any way setting ourselves up for a problem if we end up thinking of evidence that we didn't put in the list but becomes important?
I think the answer to that is, like many topics, yes and no. I think that if we, and this may happen, I mean, it's conceivable, if we get deeply into the evaluation process and something like that happens, I think at a minimum, we would have, I think it would be troublesome. But at a minimum, I think the cure would involve, or attempted cure would involve reopening the process to let everybody think about this newly discovered issue and advise and tell us what they plan to do to meet it. This issue happened the same issue happened in Pittsburgh, I believe, someplace in Pennsylvania. And I'm not sure that litigation resulted, but it certainly left a bad taste in everybody's mouth that actually what turned out to be the key factor was one that had not been in
Right.
and I think that our commitment to transparency and the other things we're trying to achieve here means that we have to do something to ensure that that this is here.
Just on that, obviously, we can make a point of saying, you know, when we first started setting out schedules, we made a point of saying, we're trying to give people guidance. This
Right.
is our best judgment.
Right.
Don't take these to the bank.
Right.
There's a you know.
Right.
And we can certainly do the same thing with this kind of stuff, at least try to forewarn people that there's that. But I agree with you that if a substantive either criteria or evidence came up, which was not on our chart, we would want to go out of our way to make sure
Right.
everybody had a fair
Right.
shot to address it.
And I should note that, you know, some of these required evidence would be broad in nature, financial projections, you know, labor studies, other types of studies. I don't believe that we will be in a position to be prescriptive as to the length, methodology, or format of those studies. I would hope that people will not be constrained by you know, any of those things. I get your point that there may be a category, kind of like a mega higher level category that we need to think about, but a lot of it is and will be stipulated in regulations if it's not already in statute. So.
And Commissioner Stebbins is taking on the project of making a recommendation to us for what outside resources we're going to need. And he will be working closely with Commissioner McHugh following on this, but this also helps with that, I think.
Right.
It begins to give us a
Right.
sense of what we can do ourselves, where we're going to need help, and so forth.
Right.
One only substantive thing, on page 10, mitigation, under evaluation criteria, you mentioned the chart has traffic, but there are a host of other mitigation criteria, the big one being environmental considerations, and probably others, but that I think we would want to include in there. It doesn't fall in any other catch-all category?
Well, let me take another look at that.
Okay.
It clearly needs to be there, and maybe there are other topics. You know, the classification piece is a little tricky sometimes. Is something a design criterion, or is it mitigation?
Okay, right.
And we have a lot of environmental stuff in the design criteria. But let me take another look
Okay.
and make sure that we.
And think of there are other
Right,
kinds
right,
of mitigation too.
Right. Yeah, mitigation is light as a topic. There's a lot of mitigation stuff that appears under another name elsewhere, but let's all think collectively about other mitigation things that we need to focus on.
Okay, that's great. So process-wise, what are the next couple of steps here?
I think that the next step would be, the first step would be to take a careful look at this and think about it, and really think about it, because this is our chance to think. You get so far down into these criteria that sometimes you lose sight of the overall objective. Think about what we each think this thing should be and do, and then make sure that we've got that captured here in some way. And then spend the time on the 12th, actually thinking about both the big picture and making sure that these criteria help us create that picture, paint that picture. And then make whatever corrections to this chart we have to in order to capture that painting, and then move on to the evidence stage and build the application. I think that's as I
So
see it.
next week would be the 7th. Is
Right.
there anything, will this be on the agenda? Do you want to talk about the weighting memo? Is there anything on the agenda for next week?
There is nothing necessarily on, actually, we could begin to talk next week about weighting factors. I've done that memorandum, which I circulated. We can talk in generalities about that. I think it's too early to be specific about
Right.
that, because we haven't really tied this down, but we can begin to talk about it and let people know what the kinds of things we're
Right.
thinking about.
Okay.
And I think that'd be a useful thing to do, actually. And I
So-
hope to have some thoughts from outsiders by then as well.
Okay, great. So we would put that Jim's memo in the packet for next week.
Right.
About the
Right.
weighting considerations. Okay. Great. Well, it's a terrific job. Thanks. Preparation for the Region C discussion. Again, I just wanted to remind everybody that at our regularly scheduled public meeting on the 21st, Thursday the 21st, we will be holding it. Do we know for sure yet where, or is it still not? Okay, it'll be in Region C somewhere at our regular time. And we are inviting comments. There will be a regular meeting, but the major topic will be how do we proceed in Region C. And we are inviting comments, and we are inviting anybody who wants to speak, who represents an entity of some sort, an official, public official, or representative of a community organization. If you want to speak, let us know. We're not going to open it up to just total random comment. Those will be on the web, and we encourage them, but we'll limit the speaking to officials or representatives of entities, but let us know if you want to speak. And that's it. We'll have the location up sometime the next week or so for people to know. Okay, we'll get back to regulation review. Attorney Grossman.
The first thing I would just make note of is that, and I circulated earlier, the copy of the grid, which has been updated to reflect the status of the Phase 2 regulations. And as you'll see, a large chunk of the subjects have been drafted and circulated for preliminary review. So that's just the first, the way we can keep track of where we are. By way of overview, I've prepared this memorandum for your consideration as just a way to focus the discussion here today without getting into the specific language that's contained in some of the drafts, to just ensure that where the direction we've taken with some of these regulations is consistent with your understanding of where you'd like to be. So with that said, I'll just, if I may, just go through some of the areas that we've covered and try to address any questions. And certainly as we move forward, we can make any adjustments to the language. And as was previously mentioned, I think bears constant repetition, that these are just the product of great collaboration and thought, but they're intended to be submitted first to the commission and then open to the public for further comment, and can be adjusted and amended at any time up until the very end, of course. So here are some of the principles that we have included in these sections. We first drafted language that applies to the host community designation. There's not a lot in that section. That's largely addressed in Chapter 23K, but there were a couple of areas that we thought could use a little clarification. So we have included some language addressing those. And they are that first, that to the extent that a proposed gaming establishment is situated in 2 or more cities or towns, that each shall be considered to be the host community. And secondly, that upon request for the election, the applicant shall forward a copy of the host community agreement to the commission for the reason I discussed earlier in the surrounding community discussion, so that we can place everyone on notice that the process is proceeding and that negotiations, or at least you should start thinking about entering into a review of the situation. So that's it. That's a pretty quick subject. We get next into the host community elections, which is a related subject. And again, there's a section of the general laws that largely governs that area, but there are a few areas of the process that we thought would be worthy of further regulation. And they include areas such as prescribing the time that the polls need to be open. There are some gaps in the election laws whereby a city and a town could theoretically have different times that polls are open. And so it was recommended that we come up with a set time that for polling so that it's uniform in all scenarios. And that we incorporate one of the commission's policy determinations that the election can't be called for, not that the host community agreement can't be executed, but the election can't be called for until the positive RFA1 determination of suitability has been issued. So
that's not what is, I don't think that's what we agreed. What we agreed was that they couldn't hold the election prior to the decision of suitability, but not that they couldn't call it.
Well, the only problem with that is that the statute says that once it's called for, it has to be held within 60 to 90 days. So I think it really would need to be tied to we have to talk about the execution.
Well, that's an interesting point, but that isn't what we talked about, I don't think. So maybe we might have made a decision which we can't enforce, but we did make it. So we gotta rethink that. Because what we had said was if a community wanted to take a calculated risk, and we could tell them it looks pretty good, we can't promise we're probably going to be suitable, you could run a risk and set the date, and particularly people who were looking for June 25th, because June 25th, there's no incremental cost. If you set up that, not very much incremental cost, that you could try it and see if you can make it. But now what you're saying is it may be that the way the statute is written, that we couldn't abort the process. They couldn't abort the process.
I don't think, Mr. Grossman, were you saying that it has to happen within that time frame? You didn't mention anything about aborting the process.
No, we did.
Right.
We had said, the marker we put down was, you cannot have an election until the suitability of your applicant has been
Correct.
assured.
Correct.
We did not say anything about when you call for an election, except
Correct.
by implication. And more specifically, we have talked to communities, and I've talked to the press about if a community wanted to take a calculated
Right,
risk, it could.
right.
But it would be forced, if the suitability was not approved, it would be forced to abort the election under our rules, if they did that. And what Attorney Grossman is saying is that may not be possible under the statute, that once they've called it, they have to have it.
Well, certainly if the applicant is no longer an applicant, they wouldn't have to have an election. I may have misunderstood what your policy decision.
Well, this is my, I worked with Mr. Grossman, this is my fault. I misread this, and I think we need to look at it again.
I think we do.
Okay,
So-
I mean, it's an
so-
interesting point. We
Right.
certainly hadn't really thought about this, but
Right.
there is, and I can see heads bobbing and shaking and
Right.
back, so
Right. Well,
other
that's-
people are
that's what-
picking this up.
That's what we did decide.
Yeah.
And I missed this, and so, but that's why we have these discussions.
Yeah,
you know,
right,
and so-
right.
That's why we're
Right.
here.
That's why we got many
Right.
bites at this apple.
That's right.
Draft forms.
Yeah,
Right.
It's draft.
okay, so we'll come back to that one.
Okay.
A quick question under
Yes.
host community elections. Just clarify that the last part of that line, no commission approval is required. Commission approval of the summary of the language that's going to be on the referendum, or just to what we were talking about in terms of approval of the date, approval of the referendum process? What are you referring to on that bottom line?
Just that the community can move forward with the election once it is called for, without the commission approving it.
So you're just reiterating that we have no role.
It was just to clarify
Other than
that
the
point.
suitability decision.
It's not it's not 100% necessary to include it, because I think its omission would signal that we don't have to do anything, but it was a policy discussion, so figured it couldn't hurt to say that you can just do it without any further approval, i.e. we're not approving the host community agreement or the summary or anything like that. You can just go ahead and do it.
Right.
I think there's another issue under host community elections, which again, we can talk about it at a later date. And question being, a municipality that has two projects, should both of those projects be voted on the same day? Or is, in all likelihood, in the greater Boston area, there may be a project which would have host community votes in two separate communities? Do we mandate or suggest even that those elections be held on the same date?
I think that is an important, and part of the reason for this is to get alignment on principles, so that then regulations can be drafted to support the principles, and so that we collectively can look at the drafts and see whether they achieve the principles we've agreed on. Okay. But I think this is a principle that we need to think about, whether we think about it today or whether we put it on the table today and think about it for a week. And that is, if there are two host community agreements, should the vote on those
If there are two host community agreements in
the same town?
In the same town, yeah.
Should there be a requirement that the election on those two host community agreements be held on the same day? Or should the commission, recognizing the home rule nature of the way the state is set up, stay out of that entirely and leave that up to the city where that is occurring? And I think it's important to decide as a matter of principle one way or the other. We already did talk about, I think, and I haven't been able to find it in our minutes, the fact that we were not going to take a role in approving the language of the summaries. That is committed by statute to city and town council, or requiring that certain things be in the summaries. That was a home rule discussion that we had, my memory serves.
No, you're right, absolutely.
And so, but this one we haven't discussed, and we ought to at least face it and decide one way or the other whether we're going to do it.
You know, my predisposition is that we've built up a pretty clear track record about deferring to the communities. And if an application comes to us from a community and we don't feel they've done a very good job of managing the process, if we feel the process hasn't been really a fair process, we may take that into consideration. You know, if there were 2 dates and one was really prejudicial because it was the last day before Labor Day or something. But my predisposition would be to say this is yet again something that we should leave in the hands of the local communities.
My predisposition is on the other side.
Really?
With the goal of creating fairness and public trust. If there is such an option, I would be in a position of dictating that they take place on the same day.
Did you vote in favor?
I was the minority voting against almost everything having to do with the home rule.
You did, okay. All right, well, that's good.
Consistency.
Consistency is
Hobgoblin.
the state bureaucrat.
So we're talking about 2 host community agreements.
Basically, the Springfield situation is what.
I understand.
But you
that.
also extend that to, if one of the Boston projects carries over into another community, do both
They
of
wouldn't
those
be
communities.
host, they would not be host.
Yeah, they would.
Yeah, they would be.
Oh, you mean conceivably Boston?
If you're, take Suffolk, because the property or boundaries extend between 2 communities.
Well, no,
But there's
you
no
couldn't-
other,
you
there's
couldn't-
no other proposed, one of the 11
Well,
applicants.
it's a different
isn't
scenario.
proposed.
It's a somewhat different
Yeah.
scenario, but would
It's a similar.
vote in one community on the host community agreement be the same day as the vote
In other words,
in the other
Yeah.
host
You've got, if you have two,
I see.
it's a different issue, but it's
Yeah.
a similar kind of a question.
Right.
Should Revere be required to have its election at the same time as Boston if Suffolk Downs goes forward? Yeah, that's.
Again, just for discussion purposes, I don't think I have it clear in my mind which way I would come down. But I can see potential prejudice in the process if both weren't voted on the same day.
I think this is a different issue. I would
It is.
say, how could you ask one community to be bound by someone else, by another community?
Force
who's-
them to
yeah.
get together.
And
Yeah,
force
they're
them to get
different-
together. That, I would put that in a different category. I would be in favor of letting that, be that as it may. I was particularly thinking of the Springfield situation. And I'm thinking that they ought to take place on the same day.
I can't think of a scenario where they would want to have it separately. I'm thinking advantages, disadvantages, I'm just not sure
I
why.
mean, you could, if they're indifferent, Springfield has the option under the law of having not a citywide vote, but a vote by ward. And, you know, I suppose if you were gonna have 2, if you were gonna do it, I think that's mayor and the council have said they're probably not gonna do that, but we don't know what's gonna happen. Should we, I'd be willing to vote on this and just put it behind us one way or the other, but I'd also be willing to wait if people want to think about it some more.
I would want to think about this some more.
Okay.
I just haven't had a chance to really see the scenarios and unintended consequences that may be.
I think there are unintended consequences. I think it's an important issue, and I'm glad that Commissioner Stebbins raised it. I am strongly leaning in the favor of the home rule approach, with the reservation that if the matter gets before us and it appears that the staging was done to sandbag one proposal, that we have remedies at that point.
Well,
We can take that into account in evaluating what we've got in front of us.
Right. And we have always said that it's pretty much up to the locals unless it impedes our process or in our judgment reflects on the equity and
Right.
integrity of the
Right.
process.
Right.
So we would be reserving that right.
Mr. Zambra, you have a
I was
comment?
just gonna note that perhaps we could just reserve our rights on this question because, as we know, well, we don't know if 1 or 2 applicants may proceeding in that particular host community. And we don't know what the thoughts of that community would be, whether or not they think that one election on one day may be the way to go. And in any event, I would imagine that there'd be a pretty significant time between the time that some of those issues surface and by the time of our next meeting, or by the time that we would promulgate our regulations, for us to consider that issue.
Right.
So it may not be necessary for the commission to vote today.
I don't think it's necessary to vote today, but I think we ought to do it, next week, but I don't think we should wait until we find out whether it's relevant. We think we ought to have anticipated the possibility and decide one way or the other. But we certainly, if you'd like a little more time to think about it, let's put it off and try it again next week. And if anybody has comments on it, let us know. Okay, sorry, thank you. Sorry for the distraction.
That's what we're here for.
Yeah, that's true, right.
The next section, since we've already covered surrounding communities, would be reopeners. And what we mean by that is the ability of the parties, or one party, to force the renegotiation of certain terms of an agreement, be it a host community, surrounding community agreement, or an impacted live entertainment venue agreement. And this section was drafted for purposes of contemplation, a scenario in which some unforeseen circumstance happens. Now, I think we all hope that each of these agreements includes provisions that would address certain circumstances that are likely, or not likely to occur, but foreseeable. That being that a certain permit is denied, or a certain permit is conditioned, or there's a problem with the MIPA process or other environmental issues. But as we all know, in the life of a contract, certain things happen sometimes that are entirely unforeseen. So we have drafted a provision that provides a procedure in the event that something like that happens. And we have conditioned the opening, and this is really where I think the commission has to give a great thought as to the level of the event that has to occur before one or the commission would allow the reopening of an agreement. And the reason this is important is that once these agreements are entered into, particularly the host community agreement, you then have an election on that agreement. So to allow a reopening has consequences. And certainly the surrounding community agreement, and to some extent the impacted live entertainment venue agreement, are reflective perhaps in some ways of the host community agreement. So it all is connected in some way. So this is an area that I think needs very careful attention. And what we have done, or at least what the draft reflects at this point, is that in order for an agreement to be reopened, there would have to be what we have termed a significant and material adverse impact caused by some event. And the way we have defined a significant and material adverse impact is based upon a principle of contract law, which essentially is what these agreements are, known as frustration of purpose. And we've taken the frustration of purpose as it's set forth in the restatement of contracts and included it in our regulations and kind of massaged it into language that we can work with. That being said, I think that needs very careful attention by the commission. This has been set in place as a placeholder to start the discussion as to whether that is at the right level, whether it's too rigid or not rigid enough as to whether you would allow a certain contract to be reopened, most likely not to renegotiate the whole contract, but just a specific term, when the term itself, the purpose of the inclusion of that term has been frustrated by some event that happened. And the mechanism we employ is basically the same as it would be in the negotiation of the agreement in the first instance, which is that once the commission makes the finding, then you have a set period to renegotiate the term and then go into an arbitration period. The timelines are different here because time is not quite as of the same essence as it would be in the initial stage. But those are the principles that we've included here, and that's why we've included this section.
Mr. Grossman and I have talked extensively about this piece, and I do think we need to figure out what the trigger for the reopener is. We've discussed the utility of that provision of the restatement of contracts that deals with frustration of purpose, and in my view, it's a litigation breeder, and much of the restatement of contracts is, I mean, the restatement of contracts is basically written for judges to provide a set of guidelines for resolving particular disputes. It's not, I think, terribly helpful in creating mechanisms for avoiding disputes. And so many of the terms are flexible and incorporate principles rather than setting out rules. And so the question is, how firm do we want to make this host community agreement once it's been voted on by the citizens? And what kinds of events are going to allow the people to go back and revisit, right? I mean, that's the basic principle. And it seems to me that there can be events that affect the applicant, hypothetically finding a ledge that you just can't build the thing on because it's just nobody could possibly have found it out beforehand, but you can't build it here. And the applicant has to revise the plans and the footprint and everything like that. That's one kind of a thing that affects the applicant. Something that affects the host community is a decision by one of the environmental agencies that you have to go through to get permits, that you can't do A, you have to do B, but B involves putting a new roadway where nobody anticipated the roadway would go, and could have a material impact on the city. What kinds of things generically described ought to permit either side to reopen the host community agreement is what we have to figure out. And for all the reasons Mr. Grossman said, once we've gone through the process of voting, it seems to me that ought to be really, it ought to be really hard to reopen the process afterwards, and there ought not be a lot of wiggle room. But there can be these catastrophic events that nobody could possibly have thought of that do in fact justify a reopening. Finding that balance is hard.
If we did nothing on this, and the applicant and the city, the licensee and the community agreed that they needed to renegotiate, could they, under today's situation?
If we said nothing, there's nothing that prohibits, there's nothing, let me say this, there's nothing that speaks to that issue in the statute. It seems to me that if we said nothing, that a voter or group of voters could take the position that, at least without another community vote,
right,
you can't change this. But there could be a disagreement on that. I suppose one could take the position that if the parties could reopen it anytime, I mean, going to the opposite extreme, they could reopen it any time they wanted, so long as there was another community vote. The problem with that is that by the time that comes around, the commission will have evaluated competing proposals, and what emerges from the new community vote may be very different from the proposal that the commission awarded the license on. So you don't want that either.
Right. Never mind if it happens 2 years down the road.
Right.
And they lose the vote doesn't pass, then what do you do?
Right, right. So it's
If anybody wants to propose solutions, please feel free.
It's a meaty issue,
Yeah.
and it's not one that, frankly, I'm prepared to vote on today. I'd like to
Yeah,
think
sure.
about it.
No, I
and,
agree.
But I think we need to think about that.
Yeah. Okay, great.
The The next subject was the community disbursements. I think I covered most of the elements of that in the previous discussion, unless there are any further comments. The next section deals with permitting requirements. And this section pertains to what the commission will require an applicant to submit as part of the RFA2 application as it pertains to permitting, whether it's federal, state, or municipal, including zoning. This does not address how this will be evaluated. That will be included in the evaluation section. This is just what documentation or what information do you want? What do you want to look at? It goes through that essentially the applicant will have to provide a chart of all the permits it believes that will be required to complete the project, whether it's a building permit, electrical permit, all that, and everything in between. It addresses the MIPA process and says that you have to submit documentations at different, reflecting different stages of the MIPA process. And then it discusses a certification from the municipality that the project as proposed wouldn't run afoul of zoning ordinances or bylaws. So those are kind of some of the principles that we include in the first part. In the second part, we basically say that in addition to any conditions that the commission may impose upon the license, upon issuance, it also has to include these couple conditions, and they are essentially that before a conditional license becomes a final license, that all permits have been issued and are deemed adequate, and that the MIPA process has been completed. So those are the basics of this permitting process. I think that this definitely needs some further review, but these are this is generally the process we envision.
Great.
The next section then deals with impacted live entertainment venues, and the theory behind this was that it is very similar in concept to the surrounding community considerations that the commission will have to make. So it reflects that process that I discussed earlier nearly entirely, with one major exception, and that is what exactly would constitute an impacted live entertainment venue. And what we set out there basically is just that the commission will consider the elements that are set forth in the statute, which include the venue's distance from the gaming establishment, venue capacity, type of performances offered by the venue. We'll make sure that it meets the definition, which is a nonprofit or municipally owned, and consistent with one of the policy determinations that the commission made earlier, we wrote in that the commission will consider whether the applicant intends to include a geographic exclusivity clause. So those are all the considerations that will go into determining whether a venue is an impacted live entertainment venue. And otherwise, it's nearly identical to the surrounding community process. Okay. And finally, for your consideration, are draft regulations pertaining to capital investments. And just recently, the commission discussed whether it would just go with the minimum, the capital investment set forth by statute, or require some other means of setting the minimum. And my recollection was the determination was to set the minimums for the category 1 and 2 at $500 million and $125 million respectively. So that's what this does.
Did we discuss that? I don't really remember. I remember that we voted not to ask for increased license fees, but I don't disagree with this. I just don't particularly remember discussing it. Did we?
I think we discussed it,
Okay.
and that we let the minimum of the capital investment at the same one, but define that minimum capital investment, capital investment. which is what we're gonna get at.
Right.
So this sets the minimum capital investments at those figures, and then it provides a means to calculate what the capital investment is. And some of the considerations are set out in the statute, but most of them are ones that we've put into one of two categories, either that it shall be included in the calculation or that it cannot be included in the calculation. And the one that is highlighted in the statute, and I think will require the Commission's specific attention, is whether you can include the cost associated with the purchase or lease or optioning of the land that the premises will be situated on. It's presently included in the section that says that you cannot include it in the calculation. And we also need to address the infrastructure costs. And the way those have been categorized essentially is that the infrastructure contained within the boundaries of the site you can include, and those that are outside you cannot include. So those are the types of considerations and the policy determinations that will require your attention. We've, for purposes of framing the discussion, we have categorized them here already. But certainly they're all subject to comment and further adjustment. The only other area that I would highlight here is the last section that talks about the bonding or deposit of the 10%, as well as the return of the 10% of the cash deposit. The first part is set by statute. It says that 10% of the total investment has to be deposited in an interest-bearing account. And this is set to the discretion of the Commission. The Commission may require, or may allow, excuse me, that the applicant secure a deposit bond, ensuring that 10% of the proposed capital investment be forfeited to the Commonwealth in cases of noncompliance. So we have written in that you would allow the applicant to either post the bond or deposit the cash. That's an area that requires your attention as to whether you will allow that or you won't. And then the other important element that the statute addresses is the return of the cash and when that happens. The statute says that at the final stage of the construction, the applicant gets the money back to finish the project. So we need to just specify when you will consider the project to be in the final stage. And what we've done here, it's very broad, and it may need further attention, is just to say that A, the applicant will have to request that the monies be returned, and B, the Commission has to determine that the project is in the final stage as detailed in the timeline of construction, and that the Commission shall consider whether the amount held in escrow exceeds the amount of capital required to complete the project. So that was just kind of a guidepost that we built in, again, to frame the discussion. Because you will, as part of the RFA2 application, you will be requiring a construction timeline. So this is just a way to make sure that, you know, there's some specificity as to what the final stage means, and that the applicant can't just decide whatever, you know, that it's way up here as opposed to over there. But that will require future further attention as well.
What is the thought process for why land acquisition isn't included?
I have some thoughts about that. Because there's a lot of variability. There could be partners, financing structures in which a partner is contributing land, for example. And there could be incentives to value that very different from others. There's also
I mean, theoretically, to drive up the value.
right, to drive up the value, right. Fundamentally, I don't see it as a investment coming from outside, even though somebody has to acquire it. The value or the asset was already here. perhaps that's oversimplistic, but I think the variability, the way in which the value will change dramatically. The value of land changes dramatically with the improvements you put on top of the land. If there's nothing there, then the value is highly subjective. So for several of those reasons, I think we should err on the side of not including it. There's another element to this. If we were, then the value of, then proponents would have to put in 10% of that amount. So it puts some stresses into the amount that they have to deposit with the commission. So from those two perspectives, my opinion is that we should exclude it. There's a similar argument with infrastructure outside of the property line.
Now, this is money, if the bidder has to rebuild a bridge that's
Right.
outside, okay.
Outside of the property. On the one hand, it'll be likely, if they have to do it, my guess is that would be the subject of host and surrounding community agreements. Quantifying infrastructure outside of your property line is always tricky because there will be jurisdiction questions and other things. So there's a variability element here that I think is important. And to err on the side of caution, if we delineate only to infrastructure that's within the property confines, that could be very, very straightforward. Now, that doesn't negate the fact that these projects will cost more than the actual capital investment as we define it. Indeed, they will likely have to spend some money outside of the property lines and certainly on land. But part of the approach here is to try to minimize the variability that's inherent with these two topics. And treat everybody equally by saying, of all this money, you will be required to put in 10%.
From the standpoint of adding capital, adding value for the capital that you invest, that analysis makes sense, i.e. the fact that you buy a piece of land for X dollars doesn't add any value to that land, right? It's just a transfer of an existing thing.
That's right.
To the extent
Transfer
you
of
put
title.
a building on the land, you've added value to the land. So from that standpoint, the analysis, and since we're looking at a value-added approach to the Commonwealth, that approach makes sense. But what if the bidder is prepared to invest $750 million, but in order to do that, the outside the boundary improvements that are going to be required are another $250 million. And those can't be taken into account at all, and therefore, what happens then to the overall, and the bidder and the applicant can't do that? I suppose that doesn't drive it down below the 500 million, but suppose it's a $600 million investment, and there's another 200 that has to be done outside in order to make it work. And they can't do it.
I'm sorry, they can't do what?
They can't
do the project
They
without
can't do
the
the
extra
project.
200 million.
And they haven't got the extra 200 million. They've got
Oh, no,
600
they
million.
would, well, right. They would have to demonstrate as part of their application in many other ways that they will have financing for everything. There's not going to be,
Oh, I know that.
nobody's going to be relieved
No,
on
I
it.
understand that, but we'd be, in effect, I'm using those numbers, there could be an infinite variety of numbers. We'd be driving away an applicant who could put up a value-added facility if we allowed that person to include the bridge as well as the structure on the ground.
We
And
would be driving them away? What do you mean by that?
because they couldn't afford it.
I don't quite follow.
Maybe I don't follow it either.
Well, all he's saying is that if you have a billion,
Yeah.
and 250 isn't gonna be counted towards your investment in the Commonwealth, you're gonna come into this proposal looking, saying to us, I'm gonna invest 750 million. You're actually gonna invest $1 billion, but you're only gonna get credit for 750 million. But the next guy just because the lay of the land is gonna put his full $1 billion into the site of the property, and he comes in and gets to take credit for $1 billion.
No, I understand that,
And that doesn't make sense to me. I mean, I don't see.
Aren't there other places in this evaluation criteria where we could capture that? It seems to me that there are.
Absolutely.
This is only for the purposes of the 10%.
That's precisely the case, yes. Yeah,
And for the minimum investment, and that's what I was.
That's right.
You don't meet the
It's
minimum.
purely for the 10% that acts a bit of, like a retainage in the construction
Right.
industry that I view as intended to make sure that an operator is not on the margins, that they have a little bit of wiggle room, and that we have a mechanism to get the project done by reserving that amount until the end. Now, in the scenario where 200 million have to be spent outside of the property line, for example, part of the thought process is that would be governed by a host or surrounding community agreement. And the hook there to make that happen, is going to be a host and surrounding community. When it comes to evaluating the value of the project and the revenues to the Commonwealth, we will clearly take that and everything else
All right, so I didn't
into
understand
account.
that. So it only pertains to the 10%?
Yes,
Correct.
it only pertains to the.
Actually,
to the-
they're a
and to the
benefit
minimum-
to the applicant.
And to the minimum capital investment.
That's right.
No, not.
No, to the minimum capital investment, because if somebody is only thinking of investing 500 million, let's say,
Right.
and they already counted what they were going to spend outside of the property line for that 500 million, then, this kind of hurts them.
Okay, so why would?
So it's
all right.
it's striking a bit of a balance.
I can, the 10%, I don't care about one way or the other. I'm fine with that. But if you use Commissioner McHugh's model, a company's gonna put 500 million in, but 100 million is gonna be outside the site. We would say to them, you can't bid because you're not investing a minimum of 500 million? That doesn't
Technically,
make
yes.
sense to me.
Technically, yes.
I don't understand that.
Well, we
By
want.
what- By the same measure that you're talking about, the land, I think, is an interesting point. You're not increasing value in the Commonwealth if you just transfer the ownership of a piece of land. But your 100 million is doing the same thing for the Commonwealth, whether it's going to inside the site or not.
Well, actually, funny, we should say, the original discussions Attorney Grossman and I had on this regulation included a third category. One set of costs that the commission may determine goes one way or another. So currently we have those that do, costs that are included in the minimum investment amount, and those that are not. There are options or scenarios in which a particular cost category, upon real close look, could go either way. But after discussing this at good length, we figured that in and of itself was too murky, shall I say, and we decided to lay this out in the either-or category.
So substantively, though, coming back to the chairman's question and mine too, I guess, why, if this person only has 500 million, and the bridge
Only
down.
needs 500 million.
Pardon me?
Only needs 500 too,
Yeah,
to do the job. Yeah.
right. And can do the job for 500, right? But the bridge down the street,
Right.
which costs 100 million, is part of the 5. Why should we say to that entity, you can't bid?
It's a good question. I guess it's part of trying to direct as much money to the destination resort if you
Right.
will,
Right.
as opposed to the surroundings.
Right.
To create the best possible destination casino, if you will, whereas all the ancillary, I mean, the bridge is important, it does create value, et cetera, but may not necessarily go towards the destination effect. If you're in that situation, you may be in a situation where too much is going to make the casino feasible by transportation improvements, et cetera, and not enough to the purpose of what we wanted, which was a big destination resort. I guess that's about as good as I can think.
Well, that's a legitimate point. I mean, I think that's an interesting point. You know, it's the same, it's sort of the same argument that I lost on about whether we should increase license fees. You know, the majority view was, we want the money to go into the destination resort, we don't want it to go into the license fee. So it's somewhat, there's a legitimate point there, which is worth thinking about.
But I think Commissioner Cameron has an interesting point in looking at the other evaluation criteria, how they might get weighted from, you know, more job creation, et cetera, based on the size of the project. I think there are different ways to balance it out. I don't have it in front of me, but I think this section also probably, we need to go back and look at the definition of capital investments as it's defined in the statute as well.
Well, yeah, you know, purely from an industry standard, in my view, is something that's an asset and will be, you know, will be with us for many, many years. So the bridge is not an inconsequential example, but the bridge outside of the property line.
Yeah, I always envisioned that investment to be within the grounds. And of course, you pick the site, so that means there are other things you have to do. That's part of your decision-making. But the inside the walls of the resort is where
What
that was my
enhances
thought
the
process.
product.
Yes.
Yeah.
From everything we've heard to date, and I'd say this is probably pretty reliable, with respect to the Category 1 license, this isn't going to be an issue. Nobody's talking about being anywhere close to the minimum. It may well be, and I don't know that we've heard any numbers for the Category 2 licenses, but they are potentially so much less capital intensive that this could conceivably be an issue. I mean, I don't know how, you know, but if you have an existing facility, it's already there, you own the land, you don't count any of that, well, you just have to improve the facility and bring in some stuff, and, you know, I don't know where you're gonna get your $125 million unless it's for stuff that's, you know, the highway, infrastructure improvements outside the site, so it could be an issue.
It could.
It's not gonna be an issue with the casinos, it sounds like, but it might be with the slots bar.
It may or may not. I mean, a large construction project, we're quickly in the 100 million category, but you may be right.
Yeah.
You may be right.
Right, well, this is obviously, you know, this is exactly what your document was meant to do, which is to flesh out the issues that we need to think about and discuss, which is what we're doing. So this is great, and I think we'll talk about this more, we'll get comment on the drafts, and we'll see where we come down. It's a really interesting conversation.
Well, fee, for example, the 85 million fee, I think it shouldn't be included either. But, you know, there's any number of, for the same reasons.
Yeah.
That doesn't build mortars.
What do we say in the regs relative to the fee?
Excluded.
The fee is excluded.
All fees are out.
Yeah.
All fees are excluded.
Yeah, good. We did, we did talk last week about waiting a week to think further about whether we should require disclosure of things of value. And we talked about it a little bit last week, and we wanted to have some time go by. I don't think we got any comments on that. Commissioner McHugh pointed out last week that there already are some requirements, but it's one I would like to have us think through. I do think, as you've heard me before, I go back to the cable television licensing industry phenomenon that I was a part of, and there was tremendous pressure on the license applications from all manner of vested interest. To get our support, we want you to do such and such. And some of that is proactive, some of that's part of the deal. You're making friends, you're making alliances, I have no problem with that. But in a sort of, to protect the license applicants, it seems to me that a fairly rigorous disclosure for any request for a thing of value or delivery of a thing of value might be significant. And if we're gonna do it, we need to do it soon, because the process is, we all know the process is going on right now. So I'd like to put that on the table to have other folks react to.
What we have in the existing regulations is a requirement that the application contain any political or community contributions that were made since the statute was passed on November 21, 2011. It seems to me that if we do this, and I think it's probably a good idea, this being require reporting of any solicitations, that could be done in the same fashion.
Done in the same fashion?
I.e. included in the application,
Okay.
a report of any solicitations for community contributions, political contributions. Political contributions now are off limits by applicants, but
Jobs.
Jobs.
Right.
Things of value.
Contracts,
Right.
things of value.
Things of value.
Right.
Could be included in the application, should be included in the
It's just to follow up on that, the statutes, sections 46 and 47 of Chapter 23K address this issue, the part of what you're talking about, which is once a contribution is made, making a disclosure. What it
Which
does
is
not, right, what it doesn't address, and the regs don't address, is the second part, which is if the applicant receives a request. We don't require, and the law doesn't require presently, any disclosure of the request itself. I did look back in some of the policy memos that were prepared, and you did address that. And though I've been slightly off in some of my interpretations of your policy results, I think what you said in that one was that you did want to include in the regs what you're talking about now, which is a disclosure of the request itself. So, as discussed.
I think we've sort of been fits, I keep bringing it up, but I think we're sort of fits and starts, and we never quite really join the issue, but does anybody disagree? Does anybody think it's not a good idea? I mean, I can see an argument that it's kind of over the top, but to me, it feels like in the issue of transparency, everything above board, it seems to me it's a step in the right direction.
I would be interested in if any other jurisdictions have a similar type of disclosure requirement. I think it sounds like a good idea as well. Someone else must have considered this, and are there reasons they do or do not do this?
Right.
Plenty of reasons why they do not do this.
Well,
No, I could see, I mean, you're gonna have three pockets of evidence or facts. You're gonna have where an applicant, has cut a check for any local nonprofit or local cause. You could have a category of they actually received a written request from a nonprofit or any other cause. But do we wind up with a third category of nothing was documented, but we have the applicant saying, well, I was asked, but when we go back to the person who made the request, they say, hey, I never did that, and then we start getting into a battle of words.
Or along those lines, we'd have to define those requests a little bit, perhaps. If you're invited to a fundraiser, is that a request? Things like that. I'm a little in between as well. I recognize that and we've talked about this, and I initially have said that disclosure is great, but I understand that there may be an unwieldy piece to this, keeping track, documenting, whatnot.
But we wouldn't, under this scenario, disclosure would be the end in and of itself. We wouldn't have to do fact-finding to find out
That's
whether.
right.
yes.
That's right.
It's simply, when the application comes out, it says that I've been asked to do A, B, C, and D and contribute to X, Y, Z, and I made the 3 contributions to, I built a new playground, I did this, I contributed to this fund, all of which is perfectly permissible, but it's out there in the open, and it prevents all of the behind-the-scenes
Allegations.
stuff, right, allegations. And it, to some extent, protects the applicant from the,
Exploitation.
yeah, the improper exploitation. And the legitimate exploitation, I mean, the legitimate requests are still gonna be made, and there's nothing wrong with that.
Yeah.
It would deter.
It would be a
Yeah.
deterrent.
It's
Yeah.
not a bar, obviously, but
Right. Right.
it's a step, it's a step in the direction, and it does give the bidder a little bit of a tool, you know, because everybody knows it has to be recorded, so.
Right.
Well, I would say, based on what I'm hearing, let's have a create a presumption that there will be such a reg, that that we will add any request, written or oral, for anything of value, be disclosed with the application. And there'll be plenty, we're gonna talk about this many more times, there'll be comment periods and so forth, but what we will now give notice to our participants that this will very likely become a requirement, and it will be retroactive to the beginning of the process. So people are on notice that this is something we're gonna be thinking about, and then we'll button this up over the course of the regs drafting. Okay, good. Pardon?
Make a break a little bit?
Sure,
At some point?
yeah.
Could I just deal with one thing, dealing with regs, before we
Sure.
break? Mr. Grossman's done a terrific job on these regs, and they are moving along, and you can see from the matrix that we are making great progress, and he will have more drafts that'll be coming out with summaries like this, so we can talk about it. As the schedule currently exists, we are planning to have a day-long meeting on March 13 to take a look at all the regulations. We are going to have a meeting with the consultants on March 11, 2 days before, to try to go through line by line the regulations and assemble them and make sure they're consistent and the like. That's the current plan. And the current plan says, that big plan that we put up there, that the goal is to have the regulations promulgated and effective on June 4. June 4 is not an effective date. It's a Tuesday. You can't have regulations published except on Fridays, and the Fridays have to be every other Friday. So it's either June 7 or May 24 that we can have the regulations. Given where we are with these regs and the matrix, the evaluation criteria, these other things have to be thought through, these policy questions have to be thought through by us. It seems to me we could use some more time to think about this, while not abating the pace at which we're doing the things that are within our control. We can extend the date that we intend to take the first formal step, that is sending a notice to the Local Government Advisory Committee, from March 15, which drives all those other dates, drives the March 11 date and the March 13 date. We can extend that to March 29 and have a shot at still having these regulations published by May 24. That's ambitious. But in a worst-case scenario, if we extend that date to March 29, the Local Government Advisory Committee date to March 29, we will meet the June 7 date, which is 3 days later than this current schedule says. I recommend we do that. I think the extra time would allow us to prepare a better product at perhaps a savings of time, perhaps losing a minimum amount of time, but it would give us the time we need to really go through this and do it in the fashion that I think we need to do it, and think through some of these principal things in the process. So I would recommend we just change our schedule and amend it so that we move in that fashion.
I think that makes all
That
the
makes
sense in the
total
world.
sense.
You know, we hope that next week we will be able to start thinking about, maybe decide on a deadline for requiring qualifiers
Right.
be submitted. And at that point, we'll be redoing that chart, making a
Right.
decision which of your multitude of options we're going to pursue, and we'll stick that change in there too.
Okay.
I did one last thing before you go. I got this package that has some things in red, some with track changes, some in black. what are all these?
Well, I'm sorry I didn't explain, meant to explain that.
Okay.
Everything in red is brand-new language
Okay.
that doesn't exist anywhere. With kind of one caveat. In the surrounding community section, the language in black is language that does not exist in the regulations, but is the language that we circulated for comment. So in the surrounding community one, I left all the black language there so you could see what we had set out for public comment, and just crossed out with the strike-through so you could see what I proposed that we take out, and put in red what I proposed that we put in. So the surrounding community one is a little different than the others.
And the same with community disbursements.
Same, well, you're exactly right.
Okay.
That,
Right.
well, that's, actually, that is in the regulations, the black language.
The black is in the regulations?
Yes.
Yeah. Oh, okay. In the previously drafted regulations?
Yes.
Okay. Okay, I get
Not
it.
adopted.
Ones that are effective now.
Right.
Right.
Oh, effective.
Okay.
So once, basically, as we move forward, kind of the next version of the surrounding community document for your review will be all red, because none of it is in
Right.
the
Okay.
existing regulations.
Okay, got it. Is this the totality of the, no, there's more.
That's what we have so
More
far.
coming, yeah,
Yeah.
right, sorry. Question. Okay, all right, well, yeah, right. All right, let's take a 5-minute break, yeah, thank you very much.
Great work.
Great stuff.
Thank you.
All right, we are ready to.
Could I,
Sorry.
I just talked with Ombudsman Ziemba about the regulations, and so two things would be helpful for our partners and collaborators to know. One is that anything that we've talked about with respect to the regulations today at a high level, we've been at the 50,000-foot level, if they want to comment on at that level, we'd welcome those comments as well. And the next draft, given the scheduling adjustment we've just made, the next time we actually put language in front of everybody is going to be toward the end of this month, when we ourselves, in a public session, consider the language that we're planning to send to the local government advisory committee. So that between now and then, we'll be applying the principles to the drafts via feedback to Mr. Grossman and the staff individually, and not collaborating on coming up with draft language. And then the next time this language sees the light of day is when we get together and have that full collaborative session.
Are you talking about March 13th?
No.
Or are you
we're
talking
gonna
about the
push-
public hearing?
No, we're gonna push back, given the fact that we pushed out, we've extended the deadline for doing this past March 13th. We're not gonna be ready on March
Oh,
13th
okay,
to have
okay.
that.
Okay, I missed that, I'm sorry.
See?
Right, I got you.
Yeah.
So this will be March 27th?
This will be right
Yeah.
in that vicinity.
Yeah, okay.
someplace, toward the end of the month.
Rescheduled.
Right.
Right, okay.
March 13 is gonna be rescheduled.
Right.
We may still use that date for the evaluation criteria and the evaluation, but not for the
Well,
purpose of doing.
that's the 12th.
Yes, I know, but
Yeah.
if we don't finish
Carry
the
over,
12th,
yeah,
we've
okay.
got the we can have the 13th reserved.
Okay.
So we really do finish that piece, because it's critical that we do finish the evaluation piece.
Is there not also the public hearing, the formal public hearing on the regs like we had
Yes,
last
and
time?
that'll be
another step.
Yes,
Towards
that'll be
June.
farther down the line. What happens is,
Yeah,
we
exactly,
will come together and consider publicly the draft that we're gonna put into the formal adoption process. We will publish that draft toward the end of the month, after we agree on it, and that will sit there until the public hearing, and we'll invite comments on it up to the public hearing date. We will have the public hearing, people can come and
Right.
talk to us, and then we consider all the comments that we've received up to the public hearing, and all the comments we receive at the public hearing, come up with the revisions, publish the revisions, and then they'll go into effect. So
Got
that's
it.
the way that works.
Great.
Public hearing on regulations is scheduled for May 3rd at this point.
Okay. Good. Great.
Right.
Thank you. All right, we are now at item 6, which is the report from the Director of Investigations and Enforcement.
You had license fee discussion, did we get to that?
Sorry, you're right.
All right, this is right.
Have a seat.
No, have a seat, this is gonna be.
Stay seated, stay seated, come on.
No walk-ons here.
Right. Sorry. I forgot 5C, discussion of the license fee. This was the issue about whether they were gonna be refundable under any circumstances and so on and so forth. I was one of the ones who was, I think, interested in this idea about whether there were some circumstances. I've been pretty much persuaded by Commissioner Zuniga's economic analysis that the Commonwealth is gonna be out a lot of money by virtue of this kind of a delay. And Commissioner Cameron pointing out that this is absolutely not the norm, and people understand that that's sunk capital, and sunk means sunk. So I'm happy to kind of let that go at this point. Anybody else?
Which is what I was advocating for, and I would just point out, I prepared to just make a comment that I view these fees as a huge incentive for project completion, for applicants to complete what they say they're gonna do, because the return is, if they open successfully, that recovers their investment. And that's the genesis of signaling that they're not reimbursable, that the payoff comes when they open, and it's not easy to walk away from a project like this because circumstances change. There will be a tremendous incentive, in my view.
Well, there's also a 10%
Not only that, yes.
down, right?
Yes.
Okay, so I think we've dealt with that. It's a nice, interesting conversation. Now we'll move on to other ones. Okay, now,
Okay.
Director Wells.
Yes, sir. So, as to the investigation status report, all 11 investigations are currently ongoing with the IEB. The 4 applicants for Category 2 licenses, those have been prioritized, and all 4 of those investigations are moving forward at an accelerated rate so that we can try and meet the deadlines set by the commission. So, given the nature of the investigations, obviously the information is confidential. We wouldn't be reporting on it specifically, but that is all progressing as planned.
Subject to the issues that we've been talking about.
Correct,
right?
correct. So we are in ongoing conversations with applicants about providing additional information, supplemental document requests, and also should they be making changes in the structure of their organization or their financing, those have to be provided to the IEB to be investigated along with the initial qualifiers. So any questions on the status? Okay. The second item in the IEB report is the discussion of processing public records requests for applications. To clarify slightly, I wanted to make sure that the commission and the public was aware that we're subject to 23K9B. So these applications for licenses, this information that we are receiving, they are determined by statute to be public record, and the language, they shall be public records. There's no discretion within the commission as to whether or not these are public records. Now, we are in the process of looking at all those applications. The state police has been through all of the applications and all the qualifier applications to review them for the redactions in accordance with the specimen form. So as the commission's aware, we put out this specimen form, and the applicants were required to comply with that and submit a second redacted copy of their application. So unfortunately, what we're finding is that in a great percentage of these forms which have been submitted, there are errors in complying with the specifications of the commission pursuant to the specimen form. So the state
vis-a-vis the redaction or not.
Correct. The greater percentage is things are over-redacted as opposed to under-redacted. I would say 75 to 80% of the errors in the redaction form are over-redactions as opposed to under-redactions. So the state police have been through all of those forms, and by way of understanding the magnitude of this process, we have 11 applications. We have over 300 qualifiers, and those documents, I would say, average about 70 pages each. So we're talking about 21,000 pages of document that have been meticulously reviewed at this point. So for going forward, as far as putting out.
I just want to
Yeah.
emphasize this.
Yes.
I don't want anybody to miss this. 21,000 pages, we've had to review every page to see whether or not they're complete, the forms are completed, and the redactions are appropriate, both points. The forms are completed and the redactions appropriate. 21,000 pages, and that's a staggering,
Right.
staggering project.
I would point out that
Staggering
it's
amount of work.
times two, because you have to have the
You're looking
the
at
actual
both. He's
form
looking at both. They're
and the
looking at
redacted
both.
form.
Yeah,
So it's
right.
And they're
actually
comparing.
twice.
So
Right.
that they're, you know, my compliments to the folks at the state police who have been going through this. It's tedious and it's very difficult work, and they did a terrific job. And what we're, you know, unfortunately, you know, our expectation had been we'd have much fewer problems with what the applicants are submitting. So, as far as going forward and what to do, we need to come up with a comprehensive plan of how to deal with this, because to go for now we have sheets that indicate where are all the problems. So they've all been noted, but they'd have to be changed. So we have to make some kind of decisions about the process to go through this. Now, my personal feeling is that we need to really have a thorough discussion, and we have to do some brainstorming on figuring out the most efficient way to do this, because we can't be doing them again, sending it back, having them come back, checking them again. This could go on forever. That doesn't make any sense as far as, you know, an efficient use of resources. So I think we need to step back and during this week figure out a real plan of how to go about so that we can let the applicants know this is what complies with the specimen form, so they are on notice of how they may have erred in their application and in their redaction form, and then go forward from there. Now, in addition to that, addition to the specimen form, we have also received additional requests for redactions. So applicants have submitted in writing to the IEB requests for additional information to be redacted. So those we are taking very seriously, and we are looking at them one by one by one. So we're going through all of those. Now, I would note that Commission had already made general determinations in creating the specimen form. So the request that I'm more likely to consider favorably has specific detail about a particular issue. I'm getting some requests, for example, say, well, this should be redacted because it's personal and confidential. But they give no reasoning why that in particular should be, when the Commission had already made a determination that that area is not something that would be subject to redaction. That is less likely to get a favorable ruling from the IEB as opposed to an applicant who gives a specific reason why, for example, this particular lawsuit, this has to do with a personal issue, and they give information why. That generally receives a more favorable ruling because I'm given more specific information as opposed to just trying to go around what the Commission has already decided. So we're going through those specifically. We've been through the first run-through of all those. There are a few of them where we'd like to do a little more research, a little more legal analysis, but we will then combine those additional requests for redactions with the specimen form. We have to combine them so we're not duplicating efforts and going through it all over again once we have made decisions about the additional redaction requests. So that's sort of where we are with the process. I would note for, just for the public's information that, examples of redacted information in the specimen form, things that were already determined should be redacted, are things about children, about personal finances, about personal phone numbers or addresses, account numbers, personal information about spouses. So it's not as if the information that was planned to be part of this redacted form had really any personal information that would be pushed out in whatever means the Commission thought was appropriate. So just want to make sure that's on the record. So that's where we are right now. Given that this task of putting together these forms, these applications that would be appropriate for a response for a public records request is going to take some time, I would defer to the Commission on when a decision needs to be made about the process by which those records would be made public, because it's not going to be this week. It's probably not going to be next week. It may not be the week after. This is going to take some time. So we may get individual public records requests for limited information, but as far as public records requests for the entire application we have to be very careful about these redacted versions. We cannot let any personal information out. We cannot let anything out that we shouldn't. So I want to make sure that we do this properly and appropriately, and then we'll take it from there. But it's a very onerous task that we've got ahead of us.
And you're performing it well. I come back to, just to jump in here, I come back to what we said some time ago. We published a specimen form. Two specimen forms. We carefully considered the contents of those. We measured the specimen forms against the statute and our interpretation of the statute. We gave people instructions as to how to redact the forms. Then we followed up with instructions about how to follow the instructions we gave them the first time. And we still got stuff that's a mess. And we've spent 2 months now, or a month and a half, doing work that is designed to protect people from themselves.
Yeah.
And it seems to me that, and we don't have that time, and we don't have that, we don't have those resources. But here we are, and we're trying to do this in a responsible way that allows us to be transparent and faithful to what commitments we made in terms of the privacy of people. There is nothing in these forms that can reasonably be viewed as an intrusion on privacy. And no matter how many times we say that, it does not sink in, because the letters we get and the vehemence with which we get those letters ensures that people haven't paid attention to what's there and what isn't there. Notwithstanding that, it seems to me that a lot of this is being driven by our decision, which we had a perfect right to make, that we would respond to public information requests by putting all this stuff up on the internet, on the web. And a concern that, quite frankly, it strikes me as unrealistic, but a concern nonetheless, it seems to be widespread and pervasive, that is going to bring down the world if we do that. And it seems to me that there is a chance that is driving some of this other stuff as well. So while I believe that we are perfectly within our rights to respond to a public records request by posting the requested material on the web. Redacted material on the web. It seems to me that in an effort to listen to what we've been hearing, we asked for comments on this, we're getting comments, they're uniformly unfavorable. And without backing down from the notion that we are in charge of this process and are going to stay in charge of the process, we have asked for comments. I'd recommend that we make a decision now that we're not going to post these on the web, that we will respond individually to the requests when they come in. We can do that and come up with a procedure for doing that. That is not labor intensive. There are ways to do that. And that will take some, one would hope, heat off of this process and allow us to move forward in a responsible fashion to get to concentrate our resources, our good state trooper resources, great people, on the investigations that we hired them to do. So I would put that at least on the table and see whether others, see the comments of others.
I think you articulated very well, Commissioner. I would support that. I think the main focus should be one of completing the investigations, and to the extent that those procedures can be put in place, you know, in a thoughtful and careful way, I would concur with everything you say.
I don't know how you feel about it.
Oh, you know, I've read very carefully. We've gotten written comments. I've read them very carefully. I agree.
Yeah.
Well, and I think that if we are taking that proactive step, I think Director, I know that how much of the resource has been used on this project. I think maybe a stern letter that says, you know, this is the process, here are your errors, compliance is necessary, and, you know, this would really be a reflection if the third time you are not complying with the redacted application specimen, this will reflect on suitability. This will reflect, it's a negative, our regulations clearly say that you have to comply with all of our document requests, and this is a document request, the third document request for the redacted specimen. So, I mean, this is, will be out of compliance with our regulation, you know, because I just, the thought of asking those troopers to do that job again, because really that's what it requires. Okay, you're sending us another document back redacted, but we're going to have to make sure it's redacted properly.
And that's my concern, is that however we do the process, if we send it back to the applicant to redo it properly, inevitably we have to check it, because we've already seen that, you know, by history, it comes back.
Commissioner, Director Wells and I talked a little bit about the process, and I think we don't have to make this a public process, but I totally agree. We just got to think through the smartest, most efficient way. It is irritating to have received so much crummy data with all that we've said, and all it's going to do is slow the process down, because we have to get this right. And I agree with your characterization. I want to, at the risk of restating things that have been said several times, first of all, this is not something that the commission wants to do. One of the perceptions has been out there that the commission is kind of running amok on wanting to be transparent about everything and put the private information out on the web. This, we are required as a matter of law to make these public records, as Director Wells read. This is unusual, if not unique, in the United States, that the legislation says that, but that's what it says. It gives certain exemptions, and it refers to the public records law, which has certain other exemptions. And we have frankly interpreted those exemptions as rigorously, and I would even say aggressively as we can, on behalf of the privacy of our bidders. This is one area where we've not been advocates of transparency. We really want to protect the privacy of our bidders. We are complying with the law which was given us as narrowly as we possibly can. And you now know, it's a huge amount of work, 21,000 pages, of which there are thousands that are wrong. We don't know how many thousands, but thousands. It's a very, very big job. But we are not going to let these things be public while there is any risk of a mistake. There's no way we want to accidentally put out some information that was not supposed to be put out, nor do we want to redact something which the law will not permit us to redact. So we're going to have to take our time, and that will definitely mean that our ability to comply with these information requests is going to take a back seat to getting this right. Having said all that, I think the commissioner is right that the put it on the web thing is just kind of like oil on the fire, so let's forget that and deal with the real issues, which is to get the documents right. We have said, Commissioner McHugh said it very clearly, and I've said it as well, we don't think there's any information that has not been redacted by us that puts somebody's privacy at risk, but we might be wrong, and we're open to suggestions if you think there are other stuff, and we will take those seriously, but not just willful, slovenly work. You know, that's not going to be looked on so favorably. So with all that said, I agree with your suggestion that we should drop, with your recommendation, that we drop the web as a dissemination medium. We on consensus on that, I guess, so there's no need to vote or anything on that.
So, you know, I will continue to update the commission on where we stand with that, and we'll just go forward with the investigations, and as public records requests come in, as I expect they will, we'll handle them on a case-by-case basis, and then we'll figure out strategically how to handle the applications.
Right.
Okay.
Right. Great.
Great.
Okay.
Thank
That's
you.
all I have.
Thank
Any
you.
other questions by
you.
the commission?
Thanks.
Thank you, Director.
No, not something else.
Okay.
Thank you very much.
Thank you.
Actually, Director
Sorry.
Wells,
Oops.
Could
Oops.
Come on back.
Oops.
Nice try.
it just occurred to me, that to the extent that complying with a specific public records request causes the IEB to spend resources stemming from the fact that there was unredacted or redacted or et cetera, crummy data, to use the chairman's words. Something that we've talked about, we would impose those additional costs on those applicants. I guess that could go without saying, but I wanted to confirm that assumption because that's also a stress on our resources.
Correct, correct. I
Absolutely,
agree with
right, right.
Thank you.
We'll do the work, but we aren't paying for it.
Yeah.
Okay, Director Durenberger of the Racing Division.
Good afternoon.
Good afternoon.
Mr. Chairman, Commissioners. First, just a quick administrative update to let you know that the Racing Division is working with the successful respondents to our two RFPs for laboratory testing services and auditing software or auditing service program. We're working on contract implementation, so those are in process. We have our seasonal hires are 99% complete.
Wow.
And we are now putting together a training schedule. We have a lot of new personnel, we have a lot of new procedures for everybody on all sides of this. So we want to make sure that everybody's up to snuff and knows what the expectations are, so that we can make our transition as seamless as possible.
The two opening days are what?
April 15th for the harness track, Plain Ridge Race Course, and I can't remember if it's June 1st or 2nd for Suffolk.
Okay. June 1st, a month and a half later?
Yes.
Wow, I didn't realize that. Okay.
As far as the Section 104, the parimutuel and simulcast law project, where we are with that, the report has been amended to address the stylistic suggestions that you all gave us and the feedback that you gave us last week. And that'll be ready probably for you first thing in the morning. And then the actual statutory language itself that we're proposing will be to you by the end of the day tomorrow. Our plan is to sit with you individually next week to the extent that is necessary so we can kind of walk you through anything, and then on Thursday we intend to bring it before you at this public meeting for final approval or other suggestions. But we're ready to go on that.
Great.
Next, I want to walk you through our rulemaking through the Racing Division. There's a whole lot of rulemaking going on, so I just kind of want to walk you through our timeline so you know where we are. Right now, we've got the Phase 1 amendments to 205 CMR 3 and 4. These are the ones that pertain primarily to the veterinary practices and medication. We've received the comments from the Secretary of the Commonwealth. We've received some written comments from stakeholders. We've collated those. The public hearing, of course, was this past Monday, the 25th, where one additional comment was heard. And we are in the process of incorporating those comments right now. The final recommended version to you will be well in advance of the public meeting scheduled for the 14th, so 2 weeks from today. And with your approval at that meeting, then the final version would go to the Register, and it would be published and in effect on March 29th, which gives about 2 weeks prior to live racing at the harness track. So we can have that in effect prior to that. It's really disruptive, of course, for any of these rules to take effect in the middle of a race meet, which is why we timed it the way that we did. Then we've got the Phase 2. I think we've talked before about the 3 different phases where Racing envisioned making some rulemaking changes. Phase 2 amendments are to 205 CMR 4, and so they pertain primarily to the rules of the running horse races, particularly in the areas of safety equipment standards and best practices. Massachusetts actually did have a number of model rules that were adopted in these areas, but had not been revisited since 2008, and there have been some significant changes in terms of standards that have been adopted in other best practices. So this is really amending existing language and just a couple of new provisions added. We're recommending today actually the initiation of this phase of our rulemaking process. So in your packet is a copy of a draft notification to the Local Government Advisory Council. This phase will include a public hearing scheduled for April 8th. That will enable us with the timeline to get the rules to take effect prior to live racing at Suffolk Downs. And so I believe since we are initiating the rulemaking process, I think last time we did this, we did have to have a vote on it. And Commissioner McHugh, I believe, was the one who made the motion last time, but I do recommend that we do that today.
Are these the co-chairs of the Local Government Advisory Council, is that what this is?
Yes.
Okay, I didn't understand that. Got it. Somebody want, so you said we do need a vote, is that what you
Yep,
said?
so I recommend
Yeah.
that the commission vote today to initiate phase 2 of our rulemaking process.
So
Great.
moved.
Second?
Second.
Any further discussion? All in favor?
Aye.
Opposed? Okay. You got it.
Okay. Let's see here. Finally, I've put before you today a resolution, which is the first time the Racing Division has done that, so I'd like to provide some context for you. You have already approved proposed medication and veterinary practice rules that will bring Massachusetts in line with much of the rest of the racing industry. In addition, we've been participating in a consortium-type dialogue regarding the implementation of the next wave of industry reform, and that's a consortium of mid-Atlantic states that have always been together and had a very strong consortium presence, and we have now expanded that to include some of the northeastern states and potentially Illinois as well. The proposed reforms are going to be firmly rooted in the uniform approach to medication, but we're now making a distinction between therapeutic medications. So these are medications that have a legitimate place in the veterinary truck and in the racehorse in training, and those medications that have no business in the racehorse at all, either because of their potential for abuse or because they can affect the outcome of the race. So we're now making, the industry is looking to make the distinction between them. And it's a very important distinction. So the RCI Board, Racing Commissioners International, has given preliminary approval to this approach, although the language for the model rule has not yet been promulgated. And our understanding is that that's going to be forthcoming in the next couple of weeks. So regulators from the Mid-Atlantic and Northeast states, we met the first week in February to indicate our intent to consider and go through the rulemaking process on this next wave. And we're meeting again actually next week, next Tuesday, to continue talking about the timeline for these reforms. It's important that the states do this to the extent that their rulemaking process allows, in concert, in lockstep. And that's the purpose of the resolution. One of the historical obstacles to uniformity is that if one state adopts a new rule well in advance of other states, and the others sort of take this wait-and-see approach, what happens is that we can actually create shifts in the industry, in the business. So horsemen may choose to run in one place and not another because of the rules that are in effect. And that's not really a good way to regulate an industry, particularly when you have wagering coming from all different states and indeed all other countries. So the thought this time is to have the commissions collectively signal their intent to consider the rule and go through the rulemaking process as close as parallel with each other as the rulemaking process allows in the individual states. We note that the West Virginia Racing Commission passed a similar resolution earlier this week, and our understanding is that there's some commitments from other states in the region that are forthcoming. So procedurally, I'm not quite sure, do I read the resolution, or does the chairman read the resolution, or how does this work?
I think you should read the resolution.
I can do
And
that.
we'll see if somebody will move to adopt it.
I can do it. Okay, so the resolution would be, whereas the Massachusetts Gaming Commission is committed to creating and maintaining a regulatory structure that promotes industry best practices in order to protect the integrity of racing and to safeguard the safety and welfare of its many participants. Whereas the Massachusetts Gaming Commission recognizes the importance of uniformity in the regulation of medication and veterinary practices, particularly in the Mid-Atlantic and Northeast region, where many occupational, and that should say licensees, may participate in more than one jurisdiction. Whereas a group of regulators from the Mid-Atlantic and Northeast region met at Delaware Park on February 6, 2013, and will meet again on March 5th to discuss the principles associated with the uniform adoption of medication rules, establishing decision levels and withdrawal guidelines for enumerated substances agreed to be of therapeutic value to the horse in training. Whereas it is believed that specific model rule language pertaining to such rules is to be considered and potentially adopted by the Association of Racing Commissioners International in the coming weeks. Be it resolved that the Massachusetts Gaming Commission is in agreement with and committed to the effort toward uniform adoption of such rules.
I agree with the principals and move that we adopt this resolution.
Second? Second. I mean, I agree, we're very much in favor and supportive of what you're doing, and, you know so much more about it than we do, but by all accounts, you, in conjunction with the folks in the industry, are moving Massachusetts out of the dark ages as a regulator and into a front row position, which is where we want to be. So I think this is great, and we will be continuing to encourage you to tell us what we can do to continue that advancement. I think this is great.
Yeah, I do too. I think, and the idea of a uniform set of rules throughout the Mid-Atlantic and Northeast region for these kinds of things makes a great deal of sense from everything you've said and everything you've provided us to read. So I think this is great as well. And to be a leader and to be on board early is important, I think. I think it's great.
Is the purpose of this resolution, I apologize if I miss it, is it
Sure.
to necessarily influence your colleagues, or is it to influence the folks at RC to kind of keep going in the direction that they're going?
It's a little bit of both, but it's more to avoid the situation where you have several racetracks in several states that are all within 2 hours drive of each other. And if the rules are different at the tracks, you can actually, you kind of make your choices about where you want to participate. And so some states may be a little more hesitant to adopt rules, and they take the wait-and-see approach, and they watch what happens in another jurisdiction. And it creates these islands, these little regulatory islands, where maybe the intentions are good and the rule is good, but nobody will participate because there are other places that are perhaps less onerous or the requirements are less stringent. And so they may choose not to race in a place that's trying to do the right thing. I mean, that's not always the case. I mean, that's not always the driver behind it, but that's certainly the thought. And so the thought is that if the commissions signal their intent, and obviously we still have a rulemaking process, we'll bring the rule to you, we'll look at the rule, we'll decide whether or not it fits for our jurisdiction, and whether or not we make the recommendation to adopt it ourselves, but at least signaling the intent that, yeah, this is what we're going to do. If everything looks good, we're going to go forward with it, rather than, well, let's see what so-and-so does first, or let's let them work out the kinks, or whatever. It's just an indication, just a signal of intent that we agree in principle with this and we'd like to move forward.
And I agree with Commissioner McHugh's point about it's nice to be kind of at the forefront as opposed to bringing up the rear, if I can make a horse racing analogy.
Particularly, right. Then I think we have a vote. All in favor of adopting this resolution as read?
Aye.
All opposed? The ayes have it unanimously. I had one question for you. We all got a rather persuasive 20-page letter from Engel and Schwartz on the issue of the dog racing payments.
Mm-hmm.
And the issue that was given to us because of one of the issues was, would they have a right to come see us?
Mm-hmm.
Where does that stand in the process? What's happening with that?
Okay, so I thought you were trying to tie it into some of the regulations.
No, I'm just, new topic, sorry.
Yeah, okay. I received that late yesterday afternoon, and I've
Right.
not had time to actually go through it substantively. So if I may.
I'm very troubled by that letter. It is not ordinary for a lawyer to go directly to the client when the lawyer knows the client's being represented by a lawyer. I've taken a quick look at the letter. I'm not at all, I haven't made up my mind whether it's persuasive or not. But the letter that was sent to the law firm was a letter that was designed to engage in a process of document production, an invitation to look at documents, an invitation to put ideas on the table, an invitation to try to narrow whatever issues are out there. And I don't know whether that's been done, but a 20-page fusillade in response to that directly to the client as opposed to the lawyer, so that things can take an orderly account, is to me troubling in the first instance. So I simply say that I have not had a chance to look at it either, and will look at it, and we'll all look at it.
Yeah.
But however long it takes Director Durenberger to look at it and to discuss it with council, and is time that we need to take.
Well, one thing that puzzled me about it was that the lawyer who was supposedly representing us was a name that I didn't remember, I wasn't familiar with.
You mean that?
That's from Anderson and
Anderson and
Krieger.
Krieger?
We
Yes.
asked Anderson and Krieger to do this.
Okay, so that, the name, the hyphenated last
Yes.
name is Anderson and Krieger.
That's right.
Okay.
We've asked them to do this. We actually did discuss this. And
Okay,
and
sorry.
we've asked, that's all right. We've asked them to do this, and they've been engaged in a process of trying to first of all, figure out precisely what the concerns were, produce documents. We got a huge document request some time ago and tried to produce the documents. We've invited them to come and look at the documents. I don't know whether that's happened.
They're coming.
It has not
I've
happened.
not been contacted.
Yeah, so we got a huge document request. We spent a lot of time trying to respond to the document request, trying to organize our files so that we could respond to the document request. They haven't. So
Okay.
there's issues there, Mr. Chairman.
Okay.
And of course, I'm saying that in my calm,
There are issues.
even-handed way.
Maybe put it on our blog.
Right? No, that wouldn't be appropriate.
Okay, great. Anything else?
That concludes my report.
Director? All right, thank you.
Thank you.
Thank you.
Thank you.
The research agenda, we are continuing to move as quickly as we can, trying to make a final decision. Do we have a schedule?
There's not an update. We've scheduled there was a cost clarification that we asked for, which we have not, a conversation that we have not undertaken, but we scheduled it. We scheduled for Monday.
And we continue to get the pool of applicants for the director position
Yes.
for research and problem gambling continues to strengthen as time goes by, which
Right.
makes Commissioner Stebbins' job a little more complicated, but it's good in the long run.
Right.
Okay, then I think we are done. Is there anything else, any other business unanticipated? Do we have a motion to adjourn?
So moved.
Second.
In favor?
Aye.
Thank you.
Stamina.
Good one.
Stamina.
You're like that.